arbitrary and violative of natural justice, offending Article 14 and 16(1) of the Constitution. Since the petitioners would have prepared better for the exam to score 75 marks, had they known the requirement of the set minimum qualifying marks before the examination. This is my first question, Manoj. The second is whether the prescription of the minimum qualifying marks in aggregated 75 is arbitrary, violative of 14 and Article 16(1) of the Constitution, since it's too high on the face of it and it is without any disclosed rational basis. Whether this honorable court should permit the appointing authority, the High Court of Rajasthan, to contend before this honorable court for the first time, that too without any record, that it was within the discretion in refusing to fill up all the 13 vacancies selected, while other 13 persons from the direct recruitment were selected. However, these candidates were. First, I will submit a few things and then I will come back to it. The order dated 5/12/2002, regulating the recruitment of in-service candidates as translators in High Court of Rajasthan, were issued by the Registrar General of the High Court on the instruction of the Chief Justice under Article 229 of the Constitution. Every rule should meet the test of arbitrariness of facet of Article 14 of the Constitution. Natural justice is a facet of the Article 14 of the Constitution. The change of selection procedure after the exam or the game is played out is unconstitutional if it is arbitrary and if such change were to be prejudicially affect the candidates. The change of rule by the Rajasthan High Court after the exam by prescribing that the minimum required marks of selection shall be 75% was arbitrary and prejudicial to the petitioners because the preparation for the exam depends on the nature of the exam or the challenge to be faced. If the applicants had known that they have to score 75% minimum to get selected, the preparation would have been more rigorous. Presently, the petitioners prepared only among the first 13 out of 21 candidates. The petitioners are not way behind 75 marks. They're quite near 75 marks since petition number 1 scored 69 marks, and therefore they would have got 75 marks by putting little extra effort had they known it earlier to the examination held on 19/12/2009. The petitioners could not appear for the examinations held in subsequent years because they had crossed the age bar. There are no impediments in granting relief after 12 years.
All right, we got it. So your case is that you would have prepared better if you knew that they're going to have a 75% aggregate.
I'm not at all talking about the appointment of those candidates. If even the mark was set up by the High Court, that you have to get this much of marks at any before deciding the notification or releasing the notification. Here, what I am saying, Lordship, I am because if I am denied now this year, after 10 years, if the vacancy come, now I cannot even appear again.
Right now, you're age bar.
Lordship, because I'm age bar and my colleagues have already reached to the assistant registrar post, which I will not be able to reach even after working for another year. So that is, Lordship, the test of arbitrariness, because I have not been treated equally the way others are treated. Reason behind, after even just 7 years,
all right, we got it to that,
Dr. Bhardwaj, can you say that because there is a higher benchmark and a certain benchmark which is not disclosed, somebody will prepare harder and somebody will prepare less harder? I don't think it's a logical submission.
Lordship, it is because the translation exam. It is
kind of, it's after all a recruitment. You're trying to get into a particular higher position of service.
Lordship.
Now, for you to say that somebody will prepare harder, I think it's illogical.
Lordship, it is how much higher? They could not resist even these kinds of marks even in next year also. So 10 years again, they were back to the same level. So what is happening? My next batch, after 10 years, who is appearing, he's appearing on the same level where I had appeared, not 75%. Either you had to continue with the same.
You can't be analyzing this, but by what they did it in the next year. We are just trying to test your argument that if they would have known that 75 is the benchmark, they would have worked harder. And because no benchmark is set, they would, because it's a competition amongst those who are trying for recruitment.
Lordship, when at the time of notification, there was no competition only.
Competition amongst those who had applied.
Lordship, 20.
You're not trying to achieve a certain level, but it's a competition amongst those who have applied.
Lordship, Lordship, this has been decided even in few matters, which will, I just read, Lordship, just barely 5 to 7 minutes, Lordship.
Password there.
Lordship. So, Lordship, the 10th point.
Yes.
Thereafter, on 4/3/17 and 8/10/2018, the advertisement for recruitment.
See, these are facts. You can skip those because we have gone through the facts.
Lordship.
What you should do is to assist us in laying down the principle.
Lordship. Lordship. So, Lordship, Lordship, any act founded on the prejudice or preference rather on reasons or factors arbitrary, which is the definition, Lordship. When both decision-making process and the decision are based on irrelevant facts, while ignoring relevant considerations, such action reflects arbitrariness. And Lordship, I will provide the note also. I will just read one paragraph, Lordship. The fine-tuning of this doctrine was taken to highest standards in Shira Banu 2017-9 SCC 1 by holding that Articles 32 and 226 are an integral part of the Constitution and provide remedies for enforcement of fundamental rights as also other rights conferred by the Constitution. Analyzing the violation of Article 14 of the Honorable Court made the test of arbitrariness void, but the general principle is Article 14's violation can be found through the test of reasonable classification as well as the test of arbitrariness. Refusal on the part of constitutional courts to nullify the provisions of an act means to be unconstitutional on the technical grounds of non-applicability of the arbitrariness doctrine to legislative actions, even when such legislative provisions infringe constitutional guarantees in the name of judicial humility, would escalate serious erosion of remedies available to the citizen of this.
You need not read out the whole note. You can now just focus on the 2 or 3
points I will mention.
All right, just
One
then
point-
tell us. All right, just tell us what the points are. You have said that candidates should have prepared better if the 75% aggregate was known to them,
Lordship.
and subsequently they became age barred, and therefore it is arbitrary.
Lordship.
That's the first point.
Lordship.
Then second point.
Second point is, Lordship, I am saying that what was referred even in the judgment in R.C. Cooper versus Union of India, that the arbitrariness in legislation is very much a facet of unreasonableness in Article 1926, as he had been laid down several
All right,
judgments of
Fair enough. That's the arbitrariness point. What is the next point? Third?
Lordship. Next point is, Lordship, that it is
Second.
even if
Arbitrariness. Yeah.
E.P. Royappa versus State of Tamil Nadu, Lordship, it has been said that the application to state action has been developed as a distinct doctrine on which state action could be struck down.
That's arbitrariness.
Violative of rule of law, Lordship.
So according to you, this is arbitrary.
Yeah, Lordship.
Fair enough. They got the point.
The next is, Lordship, equality is antithetical to arbitrariness, where the Article 14 strikes to arbitrariness in state action and ensures fairness and equality of treatment, Lordship. Now here again, Lordship, I want to talk about the equality of treatment. Why? Because, Lordship, the principle of reasonableness, which legally as well as philosophically is an essential element of equality or non-arbitrariness, pervades Article 14 like a brooding.
There's no difficulty about the principle,
Lordship.
but the application is what we have to see.
Lordship. Lordship, in state of AP, again, Lordship, it is a thing like the state of AP versus McDowell and Company. It was, again, it was, Lordship, I am just
Fair enough.
revising
Yes.
those judgments,
Right.
Lordship.
Those we look at from your submissions, no difficulty. Yeah, go to the next point. What is the next
Because,
point?
Lordship, it is a lack of legislative competence and also the violation of any of the fundamental right of Part 3. If it is not considered, then it will be, as the McDowell and the Sairabano, what they had disclosed the point of argument, Lordship. It remains the same even in this matter also.
All right.
Lordship.
Anything else?
And Lordship, the one point, Lordship, what I'm the law requires the authority to act fairly and rationally, Lordship.
Same
Because
point. It's arbitrariness. Yes.
No, Lordship, it is a reasonableness because
Which is the same thing. Reasonableness is the mirror image of arbitrariness. To be reasonable is not to be arbitrary, and to be arbitrary is not to be reasonable.
Lordship, the state shall not even deny to any person equality before the law if they all are considered in the equal protection of laws with the territory of India, and Lordship, in the state when they are appearing.
Thank you so much, Dr. Bhardwaj. We got you. Thank you. We got your point. You made the point. Thank you very much. Yes, Ms. Haripriya.
May I please, Your Lordships? On the last occasion, Your Lordships had indicated Your Lordship would like to see all the judgments on this issue. So
Yes.
we've actually filed some compilation of judgments where these issues are discussed. And we had filed it last evening, Your Lordships. Many of them are already in Mr. Ansari's compilation. Some are new ones. So I can either take Your Lordship through
Is
some of
there
the important ones or go straight away to my note.
Is there a note with respect to those? You have collated them and then formulated a proposal?
I've made a proposition note, like Your Lordships had indicated last time, on what the scheme should be and suggestions should be.
Last year.
Yes, Your Lordship.
That is how you have
Propositions.
That is,
Propositions by me and those propositions by Mr. Ragen, by Mr. Kuryakos, by Mr. Chetan Garg. I've sent all that.
Points,
Yes.
the propositions or the
Final
points that
notes?
you suggest, final?
okay.
Yes, Your Lordship.
Final notes, yes.
Yes, Your Lordship. So my note has been submitted for Lordship would kindly have that. At the outset, I mean, I'd also filed a detailed,
Through your submission.
it's called brief note on.
You got it,
behalf of
yes.
Haripriya Patni. Yeah, I'm sorry. Your Lordships. So this is a brief note. I had also earlier submitted a detailed 6-page written submission, but
There.
But
we just
I think
go
this,
through
this is a crystallized.
this is, this,
yeah.
we
You
just estimated based on what fell from my lords on the last occasion.
Yes.
Just at the outset, it is submitted that whether in principle a cutoff at all can be fixed for Viva OC is a question which has been detagged from the present batch of matters. And this calls for interpretation of the Shetty Commission report and other judgments. And our request is that the said issue of whether a higher cutoff or low cutoff in interview can be fixed up may not be gone into at this stage, because whether a cutoff at all is permissible is still moot before another bench. So anything your lordship will see on that may impact it. That's just something we wanted to highlight at the beginning. And then the second point, Your Lordships, public recruitment must not only be carried out fairly, but also must be seen to be carried out fairly. When the selection criteria changed midway by the very authority that laid down the original criteria in the first instance, after the persons in charge have learnt of the individual performances of the candidate, an impression is created that the state is not acting fairly and the change is being made to unjustly favor certain individuals, even if the same results in making overall selection process more rigorous. This originally, the submission is that ideally no change should be permitted. Once there is an rules and there is an advertisement pursuant to it, one should comply with it. And any change or departure from that can give arise to that suspicion. In
Now,
fact,
when you say selection criteria,
yes, Your Lordships.
selection criteria basically is a very amorphous phrase. Now, there may be certain types of selection criteria which constitute eligibility. So, a change in eligibility is one thing. Then there may be certain criteria which are not in the nature of eligibility, but say, for instance, shortlisting.
Yes.
Now, when your number of applications is unusually large. So, is it your case that the employer cannot change the criteria at all midway, or does it depend on the nature of the criteria that are changed?
So based on what fell from Your Lordships on the last occasion, we have in fact made that distinction in our note. We have said about eligibility and at the final stage, when originally it's the drawing up of the merit list based on the existing criteria and the selection. Once the merit list is drawn up, thereafter, the time of appointing, the authority concerned may say, okay, I will only take the top 15, I will take only the top 10, I will not choose people
All
who
right,
got
let's
less.
just quickly now lead to through your note, item 2 now.
Yes,
Point 2.
Para 2. Every state action, there's a constitution bench in Channabasavaya which doesn't talk about change in rules, but in general about public employment where the standards are very high, and that there should be a sense of non-arbitrariness in the entire procedure. That has been referred to. Every state action is presumed to have been taken after due application of mine. Hence, it is presumed that the original selection criteria were framed after due application of mine. There is no reason why more rigorous selection criteria cannot be framed before the commencement of the selection process. Third, candidates have a right to know before the commencement of the selection process the standards, criteria on which they will be judged, so that they can modulate their levels of preparation. This is something what my learned friend Dr. Bharadwaj said, and for each of our points, we've footnoted cases where these propositions are found. Similarly, examiner should have a meaningful opportunity to modulate the marks awarded to the candidate in view of the eventual selection criteria. If I may pause, especially in the case of an interview, because an exam may still be more objective. In the case of an interview, as it happened in the Kerala case, if the interviewers do not know that there's going to be a minimum cutoff, they may give me a certain marks. But if they are aware that by giving me less than a certain cutoff, I'm going to be excluded from the final merit list at all, their considerations may be quite different while marking me. So it is not just the candidate, but it is also like in terms of interview and exam. I don't believe that a candidate will prepare extra for the exam. I believe you should anyway do your best and work hardest, irrespective of what the cutoff marks are. But for example, interview, for any reason, I may choose to not prepare for the interview as hard as I possibly prepare for the exam, because I think it's anyway an aggregate of both. But tomorrow I'm told, no, I'm going to fix a cutoff in the interview. Then obviously my criteria has changed. Interviewers also are similarly placed. They may have marked you differently. Were they aware that based on a lower mark, you're going to be precluded from being on the merit list itself? So the fact is, everybody should know what is before them and what to anticipate. And that itself is a principle of non-arbitrariness, because if the rules of the game keep changing through the process, nobody knows what to expect. Para 4. Overall, the selection process must not cause frustration to the candidates. In our country, a large number of unemployed youth apply for public posts, filling the forms, preparing exams, traveling to exam centers. In this background, as recently held by this honorable court, those who are successful and declared to be passed have a reasonable expectation that they will be appointed. Point number 2, and this is just our general principles, why we say in general it should be a rule that once a selection process commences, criteria change should not be permitted. If your lordship is going to permit it, then it should be an exception to the rule and not the rule itself. Number 1. Number 2, no change in eligibility criteria unless advertisements and rule permitted. This is what fell from your lordships, that eligibility is different because I have a right to be considered. I don't have a right to be appointed. Now, therefore, there are judgments of this honorable court which very clearly says you have a right to be considered. So if any eligibility criteria, meaning a cutoff in an exam or interview, is tampered with, that will prevent my name from being in the final merit list, not the select list, but merit list. To that extent, eligibility criteria should not be changed at all. However, there are
You formulated it.
I formulated, but there are two.
Go ahead.
I'll read it here. Articles 14 and 16 of the Constitution recognize a right to be considered for appointment on equal terms as other candidates. There can be no change in the rules of game so as to alter the eligibility process of any of the stage of the selection process, as a candidate has a vested right to be considered for appointment in line with the existing conditions laid down in the advertisement. I'll cite the judgment for this about why the advertisement plays a crucial role, not just the rules. This means that the eligibility criteria can neither be relaxed nor made rigorous, since a candidate has a right to be considered at an equal footing with and only with other candidates eligible as on the date of the advertisement. The reason I have made this proposition, Lordship, there were certain cases where after the advertisement, they have relaxed the cutoff in exam or interview. The question arose, more people are being considered. So your right is not being affected. You're anyway being considered. Instead of 50 people being considered, now 100 people are being considered. So how is it affecting your right to be considered? So this honorable court, 2 judges of this honorable court have said, no, it is your right to be considered with the people you are meant to be considered on the date of the advertisement. So if originally only 50 people were to be considered with you, but tomorrow, because of a relaxation, 100 people have been brought into the pool, it affects your vested right of being considered. So this change in eligibility cannot increase nor can it relax any requirement, because there also my vested right to be considered in accordance with what is laid down in the advertisement is being tampered with. And that is the second proposition we are presenting for your lordship. So eligibility conditions should never be tampered with, whether it is to make it higher or lower, because in the case of Tej Prakash, the specific issue was a higher cutoff. And that is what the court was concerned with at the time of reference. But tomorrow, equally a situation will arise. They will ask if it is reduced, then your right is not being affected. So can I reduce? Can I relax? So it is just so that if your lordship is laying down guidelines, this be taken into account.
Now, let's go to the third point that you have made, the
Yes,
third
Lord.
Roman point.
Yes, your lordships. And then as far as this, there are 7.
Cutoff. Power to fix it.
On the third point itself, power to fix a higher cutoff. Yes, your lordship.
So 3 covers changes other than those of eligibility.
Eligibility. At the point like Marwaha. So selection is complete and there is a merit list drawn on the basis of the selection process. Once that merit list is done, The authorities
No
who said,
problem.
I will take only the top 10. So here I say once the various stages of
There also you say that structure the discretion.
Yes.
Because they shouldn't really say that give me the candidate, I'll decide what to
Yes,
whom
Lord.
to appoint. One, you must follow merit. You can't take a person lower down in merit.
Yes,
That's what you
yes,
say.
Your Lordships.
Why don't you read it? You have formulated it well, actually.
Yeah, thank you. Right. Once the various stages of selection as advertised are completed and the merit list is drawn up, then comes the stage of selecting the candidates to be appointed from this merit list. As held by this honorable court time and again, no candidate has a vested right to be appointed. The selection committee appropriate authority can decide how many candidates from this list it chooses to appoint. However, this discretion is not absolute and is subject to the rigors of non-arbitrariness and fairness enshrined in Articles 14 and 16 of the Constitution. Hence, such a discretion has to be exercised keeping in mind the following safeguards. The list of candidates chosen must be in the order of merit, and no candidate can be picked up over and above her or him in the merit list. Any cutoff or criteria on the basis of which the final select list is prepared must be notified in writing along with the reasons. There are judgments from Harla and all your lordships where they say that all decisions taken should be published. It can't be in the secret chambers. So in fact, in the Kerala judgment case, we didn't know that they had fixed a cutoff for an interview till we moved RTI.
Normally, that's how it's happening.
So any cutoff or criteria on the basis of which final select list prepared must be notified in writing along with the reasons. This is a basic requirement of transparency and the rule of law. Further, this would aid judicial review by preventing the recruiter from raising before the court as afterthoughts reasons that did not in fact guide the change.
So disclosure with reason.
Disclosure with reasons.
And
Third, the cutoff or criteria should be decided before the merit list is prepared so that it does not appear to be tailor-made to suit certain candidates. Justice should not only be done, but it should seem to be done. For example, you just stop at a particular level. I mean, the question would always arise, why didn't you think of this a little earlier? So before, say, the aggregate is done, in the case of exam plus interview, before the aggregate marks itself, if the committee would decide that we won't take anybody who have an aggregate less than 70, that would be fair. But after the merit list is prepared and it's in front of them, they choose, then it gives rise to a suspicion. Why did you stop here and not 5 marks below? D, last point, the rules of the game can be changed only in a way so as to make the selection process more rigorous. In other words, no relaxation, concessions, any other measures enlarging the zone pool of consideration should be permitted.
But this will really not arise because, really speaking, once the process has been undergone, then the employer will only say, well, I'll only take the first 10. I will apply, say, a cutoff of 75% mark or 60% marks. They're not going to, if there was a cutoff which was notified earlier of, say, 60%,
yes,
and the employer then says, no, I'm applying a cutoff of 75%, that ex facie is, that's illegal.
Yes, Your Lordships. It happens.
You can't widen the field of.
Yes, you can't widen the field. And just to point out, Your Lordship, Manjushri's 3 judges, there is a Manjeet Singh, which is exactly contrary to Manjushri, which is also 3 judges. Manjeet Singh versus ESIC.
Will you just give us a citation?
Yes, Your Lordships. It is 1990, Volume 2, SEC, 367. It's there in the compilation we have submitted, even Mr. Ansari's compilation, page 97 of Volume 1 of his compilation. This is 3 judges contrary to Manjushri. And as far as the advertisements are concerned, Your Lordships, even a recent judgment of this court of 2023 has very clearly made a statement that the advertisement should carry it and you have vested right as on the date of the advertisement. And that just having one is whether the rules permit a change. Second is whether you have conveyed that in your advertisement.
Can we just see Manjeet Singh for a
Yes,
second?
Your Lordships.
It's in this compilation which you have given us now?
Yes, in my compilation, it's at page 62.
Volume 1 and Volume
Yes,
2, right?
Volume 1. Volume 1, page 62 in my compilation. And Mr. Ansari's compilation, page 97, thanks. Para 2 and para 6.
Let's just see that.
Which volume you said?
Volume 1.
Volume 1.
Page 62.
Yes.
This is again a case where there was no interview marks cut off prescribed.
Let us see what they say.
Yes, Your Lordship. Para 2, as already indicated, the direct recruitment was on the basis of examination and interview. The advertisement did not prescribe any pass marks in the interview, though for the written examination, 40% was prescribed. Selection was, however, made on the basis of 40% in the interview test, and those who did not secure 40% in the interview were not selected. Challenge was made by the unsuccessful candidates, questioning their rejection by contending that in the absence of any prescription of marks for the interview, there was no justification to apply the 40%, similar to Manjushri. Then straight away, if Your Lordship will go to para 6, at page 64 of the compilation, bottom. So far as this remaining question that was debated before the tribunal is concerned, we are of the view that the scheme intended for recruitment should be on the basis of an examination comprising of written test and interview. We agree with the submission of Sri Madhav Reddy that interview has its own place in the matter of selection, appropriate to require every candidate, selection process and the choice of the candidate. Once this is recognized, it would be appropriate to require every candidate to pass the interview test, and for that purpose, there should be a basic limit provided. In the absence of any prescription of qualifying marks for the interview test, the same prescription of 40% as applicable for written examination seems reasonable. That has been also the view expressed in so and so and so and so. We approve of the view. Accordingly, we modify the direction of the administrative tribunal and hold that in the oral examination, the pass mark shall be 40% and 40% marks shall be.
So here again, they had put this cutoff of 40% after the process had begun. And this judgment in Rajesh Sood was Justice Punchi's judgment in Punjab and Haryana in the Supreme Court.
I'm told it's not reported and we've not been able to find it.
Oh, I see.
That's what.
Sir, ये देख लो, ये Rajesh Sood versus Director General Employees State Insurance Corporation, decided on 7 August 1985. ये page 65 को मिलेगा volume 1 में. ये check कर लो, ये it is the Supreme Court. I think it must have been more. It must have been.
पीछे नहीं आया होगा.
Then there's another 3 judges, Your Lordship, in Ramesh Kumar versus.
Punjab and Haryana. You've got the citation.
Yes.
Then which is another one?
Ramesh Kumar versus High Court of Delhi. That's at page 202 of Mr. Ansari's compilation and 119 of this volume 1 Your Lordship is reading. Ramesh Kumar versus High Court of Delhi.
What's the citation?
10, 3 SEC 104.
Yes.
Yeah, paras 13 to 18, Your Lordships. This was again a case of an interview mark.
Where is that? 124 of your compilation.
Volume 1, yes, Your Lordships. 119 and 202.
Where does the judgment begin actually?
119.
119. At para?
Para 2 has the facts in brief, if I may trouble Your Lordships. The facts and circumstances giving rise to these petitions are that in order to fill up 20 vacancies in the cadre of District Judge in Delhi, Respondent number 1, the High Court of Delhi, issued an advertisement on 19th of May 2007. Out of these 20 vacancies, 13 were to be filled up from the general category candidates, 3 from scheduled caste candidates, and 4 from scheduled tribe candidates. The petitioners who belong to scheduled caste category faced the selection process. The result was declared on 3rd January 2008. All the 3 vacancies reserved for scheduled caste candidates could not be filled up as the respondent number 1 found only 1 person suitable for the post. The 2 petitioners herein were found unsuitable on the ground that they did not secure the required minimum marks in the interview. Hence these petitions. Here again, your lordships, at para 7 is the rule, the relevant part of the instruction, which does not have a cutoff for the viva voce. The relevant part of the said instructions reads as under para 7. A candidate shall be eligible in the viva voce only in case he secures 50% in the written examination, so and 45 marks in the reserve category. Interview marks will carry 250. A candidate of general category must secure a minimum of 50 marks, and a candidate of reserve category must secure a minimum of 45 marks in the viva voce. It was also provided that the final merit list will be drawn up from among the candidates who have secured the stipulated minimum marks in the written examination, and also the stipulated minimum marks in the viva voce by adding up the marks in the written
So
examination.
this was notified expressly that
Yes,
you must
sir.
secure.
Yes. But still Manjushri was applied. Thereafter, they rely on Durga Charan, Manjushri at para 14, 13, 14, they rely on various things, and para 15. Thus, the law on the issue can be summarized to the effect that in case the statutory rules prescribe a particular mode of selection, it has to be given strict adherence accordingly. In case no procedure is prescribed by the rules and there is no other impediment in law, the competent authority, by laying down the norms for selection, may prescribe for the test and further specify the minimum benchmarks for written as well as viva voce. In the instant case, the rules do not provide for any particular procedure criteria for holding the test, rather enables the High Court to prescribe the criteria. This court in All India Judges versus Union of India accepted the Shetty Commission's report in this regard, which had prescribed for not having minimum marks for the interview. If I may just pause your lordship, there is another confusion as far as minimum marks for interview is concerned. Shetty Commission, there are two reports. The first report was the one accepted by All India Judges. There are three reports. The first report was about pay commission for judiciary, and that particular commission report did not talk about viva voce, or did not say that no cutoff should be prescribed for viva voce. That report was the one considered in All India Judges. It is the second report of the Shetty Commission which says that there can be a cutoff for viva voce. That has, from what little research we have done, we have not been able to find any judgment specifically upholding that. But all judgments, including this judgment, have gone in the presumption that All India Judges has approved this no cutoff. But in reality, if one reads All India Judges, that issue does not even arise there. Yes, Lord. So in this case, the rules. Yes, Lord. So in this case, the rules didn't provide for cutoff for the interview. It left the discretion to the High Court, so to speak. But in the advertisement, they had given a cutoff. Despite that, it was cut off, it was struck down, saying that this could not have been contemplated under the rules itself. Para 18, Your Lordships, last three lines of Para 18. Therefore, in the instant case, in the absence of any statutory requirement of securing minimum marks in interview, the High Court ought to have followed the same principle. In fact, such a fact situation, the question of acquiescence would arise. The reason I have pointed this out, Your Lordship, there are different types of change in rules. If rules permit, advertisement does not say so. Rules are silent, advertisement provides for it. Rule specifically excludes advertisement. So there are 3-4 different permutations.
So rules also don't specify, advertisement also don't specify.
That's a clear cut.
Even after the written examination,
Yes,
before going for Viva OC also, they don't inform the candidate. That's again the fourth
Yes.
category.
Fourth category. So there are multiple ways in which these rules can be changed. So our submission is rules should permit and advertisement should also specify. In that, Your Lordship, there's just this one case. There's another case where again the zone of consideration was reduced. I've not read it, but just pointed out where the number of vacancies were notified and candidates had to be called for interview. The rule was 2 or 3 times the number of vacancies will be called. So the advertisement said 750 vacancies are there approximately, but it can be changed. So 1,500 candidates had to be called for interview, double the zone of consideration. After a point of time, after applications were received, they changed it to 470 vacancies. It was drastically reduced by 300. And only 940 candidates were called for the interview. The court upheld it. This honorable court upheld it, saying that, the notification says that the number of vacancies can change. But the question arises, it says 750 approximately gives you the feeling and the belief that it will be in and around 750. But to reduce it drastically to 470, this would be a clear case where if the authorities had been told you had to give it in writing, the reasons why you drastically reduced it, it may have helped for the purpose of judicial review to see whether it was arbitrary or not. And then there's judgments, Your Lordships, I won't read it, but Suresh Kumar, Lalit Kumar Patil versus State of Gujarat, 2023. The last one. Yeah, the last one. Just one last judgment and I'm done, Your Lordship.
Yes.
It's at page 253 of this compilation Your Lordship has Suresh Kumar, Lalit Kumar Patel versus State of Gujarat.
Page 253.
Yes, Your Lordships. Lordship, the neutral citation is 2023 INSC 145.
Very good.
Thank you so much for the new citation.
Chair for it. He's the one who pointed
Yes,
it out
very
and
good.
told me I should use it.
We will encourage this.
It's at page 253.
Now we are working on neutral citations from 1950 through to
To the
2013.
13. From 14, Your Lordship has it.
Yes.
So we tried to make a list of that. Para 2. The decision of the Division Bench of the High Court of Gujarat giving its imprimatur to the decision of the Departmental Selection Committee in reducing the qualifying marks for the post of Supervisor Instructor Class 3 after publication of the result to facilitate the inclusion of candidates constituting horizontal reservation is under challenge in these civil appeals. That is reducing a criteria. Then if Your Lordship will go to para 12. It's at 255, para 12, right at the bottom, Your Lordships. The aforesaid advertisement does not give any room for any interpretation otherwise. It does speaks about the manner by which a post has to be filled up, inclusive of a special reservation in the form of horizontal one. The power of either cancellation or amendment has to be exercised by way of an amendment to the advertisement, except in case of reduction of seats. Further, such a power has to be exercised either at the initial stage, which only means before writing the examination, or during the process, and thus giving ample indication that publishing the result would mean the completion, and therefore the declaration of selected candidates would only be consequential. Para 13. The selection committee held a meeting on 5/10/2016, proposing to further relax the cutoff marks fixed only for the candidates belonging to the horizontal reserved categories. Accordingly, the cutoff marks for general category have been kept intact. Thereafter, a subsequent meeting was held on 17/12/2016, by which the earlier decision proposed to be implemented on 5/10/16 was cancelled. The meeting was attended by all the members of the selection committee. Thereafter, if Your Lordship go to para 23, where the discussion starts, that's at page 258 of the compilation. Another unique feature of the present case is that the selection committee had reduced the marks to facilitate horizontal reservation by treating it as a vertical reservation. Admittedly, the rules do not provide for such reservation to be treated as a vertical one. Likewise, the rules do not fix any cutoff marks. An advertisement made pursuant to a notification binds the parties. It has got all the trappings of a statutory prescription, unless it becomes contrary to either a rule or an act. A change, if any, can only be brought forth by way of an amendment and nothing else. Such an amendment, even if it is permissible, can be tested on the touchstone of Article 14 of the Constitution of India. It cannot be introduced to give an entry to a special reservation in a case where a right becomes accrued to a candidate under a policy decision reduced in the form of an advertisement to be considered for a post in the absence of any eligible candidate from the horizontal category. It is true that a candidate may not have a vested right to the post. However, it cannot be confused with the right to be considered in accordance with law. A law which enables a candidate to get a post cannot be changed to facilitate another group of persons, since the candidate acquires a vested right to be considered in accordance with law. And thereafter, they cite another judgment we have relied on, Devan Katti's case. And then they at para 25, admittedly, in the case on hand, the appellants are entitled to get the post as per the advertisement issued. The advertisement has not been amended. It was modified on the advice of the government, though an earlier decision was taken on similar lines but wisely withdrawn. Fixing cutoff marks for a particular category has got a rationale behind it. Reducing it only for the purpose of providing employment to a particular category when others have already acquired some right would be an affront to Article 14 of the Constitution.
All right.
Yes.
And the Devan Katti's case relied on says that all.
The judgment in Manjushri and Tej Prakash was cited,
Yes,
and they, in para 29,
they differentiated.
and they say that it's not necessary for us to go into
Was to
that.
go into it.
On the facts, we do not think the said issue has any bearing.
They say it's different.
Para 930, they say the decision to reduce the cutoff marks is not based on objective criteria, namely the suitability of the candidate to the post, but for extraneous reason, that is to accommodate otherwise ineligible clients. So actually the judgment can rest on this instead of going into any broader aspects of the judgment.
Yes, Your Lordship. I'm obliged. So
Thank
we've
you.
given as many
Thank
judgments
you.
as we think
Thank
is
you, Ms.
necessary.
Harikar. Thank you. Okay, this-
Yes. Lord, I filed an additional.
File something rather than.
Additional written submissions, my lord, because I filed the main one in the Kerala matter. So this is the additional written submissions which are there in the drive, my lord.
Your written submissions, right? Additional.
It's named additional written submission. I think my office sent a Word document. I'm sorry, it's a Word document.
Additional written
Yes.
submissions, yes.
So folder got final notes for 18th and then additional written submissions. My lord has got that. My lord has got that. I've got one hard copy. Hard copy. Just give one.
You are that additional written submission,
Yes,
right?
My lord has got that.
Just 1 minute.
Yes.
Petition, para 60.
Yes, sir. इसमें पढ़ना है इसके।
Before I read, can I take just 2 sentences before I
Yes.
start reading the note? The note is, my submission is twofold. One, this reference is on the context of Tej Prakash, my lord.
Yes, yes.
Tej Prakash doubts Manjushri on 2 grounds. One, Tej Prakash assumes in para 12 that Manjushri says if there is no minimum cutoff, then the 10 best people, 13 best people have to be appointed. With utmost respect, my lord, Manjushri doesn't say that.
Yeah.
So the first ground for referring Manjushri to a larger bench, with utmost respect, may not arise. Second, my lord, Manjushri in Tej Prakash, the second reason given for referring Manjushri is stating that Manjushri does not notice Subhash Chandra Marwa. With the most respect, Subhash Chandra Marwa deals with a completely different situation. Now, my proposition is this, before I read the note. Manjushri deals with a situation where the selection committee fixes a cutoff mark before they get into the select list. So there is a process, the candidate has a right to be considered, but that right is curtailed by introducing a benchmark after the viva, after the written test, and therefore the candidate does not get into the select list.
Before consideration.
Before consideration. That is the issue in Manjushri. Whereas Subhash Chandra Marwa is a case where the candidate got into the select list. Once the candidate got into the select list, then the appointing authority applied a benchmark and said, we are appointing only the top 7. So there, the principle of no indefeasible right to be appointed, etc., comes only in the case of Subhash Chandra Marwa and not in the case of Manjushri. That is the difference. So Manjushri, there's no mistake committed by Manjushri in not referring to Marwa, because Marwa does not deal with the situation at all. So that
Marwa was a case where the authority, after the process was over, said we'll appoint the top 7.
Correct. There also, it's not like the candidate is remediless. So in that case, suppose there were 7 candidates. The appointing authority, that's the government, says I'm appointing number 1, number 5, number 7.
That is then a problem.
Of course, it can be challenged on the ground of arbitrariness.
Choose.
Yes. So, but this principle of changing the rules of the game, etc., does not arise in that case. So in Marwa, what has happened is the rules provided only one thing, which is you write the exam, you get 45%, you come in the select list. So in Marwa, after this exam, 40 people got into the select list with 45% marks, out of which there were 15 vacancies. The 15 names were forwarded by the High Court to the government appointing authority. Government says, because on the facts of that case, on the previous round, you had said 55%, High Court itself said, whatever the reason is, the government said, we are now applying 55%, and they took number 1, number 2, till number 7. So the candidates who were in that list, the 8 to 15, they said there were 15 vacancies, I was in the 45%, you should have appointed me. There the court said, no, this is not fixing a cutoff, this is the appointing authority selecting the 7 best people. There is no right for you to be appointed, therefore you have no case. So with utmost respect, so to say that Manjushri is not good law or is doubted because it did not consider Subhash Chandra Marwa may not be entirely legally sustainable is my submission. So there are 2 reasons. These are the 2.
You have you formulated.
Yes.
Let's read that.
Yes. Okay. Can I just say one more sentence?
Para 3, then you can.
Yes. In this context, this honorable court in the said reference order doubted the correctness of the principle laid down in Manjushri for the following reasons. 1, that a strict application of the principle of law laid down in Manjushri would mandate that the High Court was bound to recruit 13 of the best candidates out of 21, irrespective of their performance. 2, that the judgment of 2 judgments of this honorable court in state of Haryana versus Subhash Chandra Marwa was not brought to the notice of the honorable court in Manjushri. It was observed that in the case of Subhash Chandra Marwa, while dealing with the recruitment of district judges for the state of Haryana, it was held that the government, while making appointments from the list of eligible candidates, can fix a score which is higher than the eligibility with a view to maintain higher standards of competence. It is humbly submitted that the same is an incorrect interpretation of the ratio of Manjushri for the reasons below. 1, the judgment in Manjushri does not lay down an absolute proposition that in the absence of minimum qualifying marks, the best candidates must be appointed irrespective of the marks scored by the candidates. It is settled position of law that there is no indefeasible right of a candidate to be appointed, and Manjushri does not state anything to the contrary. 2, The decision in Manjushri arose in the context of recruitment to the post of district election judges in Andhra Pradesh State Higher Judicial Service, where after the written examination and the interview were concluded, the subcommittee of the full court introduced the requirement of minimum marks for the interview, and as a result of the same, the candidates with higher aggregate marks were kept out of the merit list based on their marks in the interview. The principle of law that rules of the game cannot be changed once the game has been played was laid down in Manjushri and was applied at the stage of preparation of the merit list during selection before the said list were sent to the state government for appointment. That is the distinction, my lord. Now 4.3. Further, this honorable court in para 33 of Manjushri categorically holds that prescription of minimum marks for interview is not illegal. It further holds that the authority making rules regarding selection can prescribe by rules the minimum marks both for written examination and interview, or prescribe minimum marks for written but not for interview, or may not prescribe any minimum marks for either written examination or interview. It is specifically held that where the rules do not prescribe any procedure, the selection committee may also prescribe minimum marks for the interview, but before the interview. In this context, it is submitted that the judgment in Manjushri cannot be doubted for not considering Subhash Chandra Marva for the following reasons. 1. Subhash Chandra Marva was a case where the appointing authority of the state government adopted a yardstick of minimum marks in exercise of its discretion to make appointments from the list of eligible candidates prepared by the Public Service Commission, and the relief was denied to interested candidates on the settled principle of law that there is no right of appointment in a candidate merely because the vacancy was indicated. B. The said factual situation is different from the case in Manjushri, where the criteria were changed while preparing the merit list to be sent to the state government for appointment. In this regard, this is important, reference may also be made to the opinion of Honorable Justice Owens in the split decision of the two-judge bench of Salam Sarabjit, where it was observed that the judgment of Subhash Chandra Marva applied only in cases where selection procedure had been completed and thereafter the appointment is denied for good reasons. Now, just one sentence to add here, my lord. In the same judgment, Justice Bhanumati's judgment, which basically she in that judgment, para 25, what is said in that was a case where the marks was prescribed before the viva. So Justice Bhanumati, while dismissing the case of Salam Sarabjit, says, had it been a case where viva marks were fixed after the interview, the position would have been different. So the decision in that case was Justice Bar, even though the
It doesn't apply Manjushri.
It applies Manjushri. It says on the facts of that case, they are not applying Manjushri because in that case, viva marks were fixed before the interview. Whereas in Manjushri, it was fixed after. So I'll read para 30 later. In para 30, there is one line where the specific sentence is para 25. Sorry, para 20 with a specific sentence which says, had the full court met and fixed the viva marks after the interview, the position would have been different. So that is the basis for that distinction. There's no other reason why Manjushri was not applied on that reason. Now, Lordship, the next question that arose in the last hearing, was whether the Manjushri endorses Umesh Chandra Shukla. So then the question arose whether if there is a conflict, Lordship, remember last time, if Manjushri endorses Umesh Chandra Shukla, and if Umesh Chandra Shukla and Subhash Chandra Marva are conflicting, then what do we do? That was the question. Now, my respectful submission to that, Lord, is there is no conflict between Umesh Chandra Shukla and Marva. Umesh Chandra Shukla was a case similar to Manjushri. That was a case in which the selection committee, after the interview, after everything, before the list was sent to the government for appointment, introduced an aggregate of 600 marks for written and viva. And based on that aggregate, many people who otherwise would have been eligible to be considered for appointment were not put in the select list. So the question in that Umesh Chandra Shukla is similar in facts to Manjushri, whereas Tej Prakash is similar in facts to Subhash Chandra Marva. So in this case, in Umesh Chandra Mishra, what this honorable court held is, you have no right, you have a right to be considered. You cannot interdict that by introducing this cutoff when the advertisement, etc., did not provide for it. Even that judgment, para 14, specifically, I just read that sentence. The question whether a candidate included in the final list prepared and forwarded by the selection committee may be appointed or not is a matter to be considered by the appointing authority. So what the difference is this, my lord. One set of cases, there is a barrier created before a candidate gets into the select list. Those are governed by Manjushri, Umesh Chandra Shukla, etc. The law says you cannot do it unless the rules prescribe, etc. The second are the kind of cases where after you are in the select list, the appointing authority fixes a cutoff which was not there earlier and says, I'm appointing only 5 out of 13 vacancies, or whatever the reason is. There, the issue of change in rules does not arise. But however, like I said earlier, my lord, the candidate is not remediless. The candidate still has the principles of arbitrariness, Article 14, all that is available for him. If it can be shown that that criteria, that cutoff prescribed by the appointing authority was for any other reason, was to favor one person. One example, obvious example, which I said earlier, my lord, if they don't follow the inter se merit, if they take 157, it's a ground for arbitrariness. Or they fix out of 100 marks, they fix 95, 99% as the cutoff, and they take only 2 people. Maybe a ground for arbitrariness. Or that depends on facts of each case. But this principle of change in the rules of the game after the game has started does not arise in cases of Subhash Chandra Marwa and in the case of Tej Prakash Patel. So there is no conflict between Umesh Chandra and
now let's go to para 6 of your
yes, Manoj. Can I read 4.5 for a second?
4.5. All right.
That's only distinguishing each of them. You are saying.
No, what I'm saying is why there is no conflict between these two, Manoj.
All right. Can formulate it.
I'll quickly.
In a minute, you can read.
Yes. Similarly, there is no conflict between the 2-judge bench judgment of Umesh Chandra Shukla relied upon in Manjushri and the 2-judge bench in the case of Subhash Chandra Marwa, as is evident from the following. A. The judgment in Umesh Chandra Shukla arose in the context of an additional requirement of minimum aggregate marks, which was introduced by the selection committee after the selection process were completed for the post of so-and-so and daily duty services. The said judgment did not pertain to the discretion of the appointing authority as in Subhash Chandra Marwa. It is specifically observed in Umesh Chandra Shukla that the question of whether a candidate included in the final list prepared by selection committee may be appointed or not is a matter to be considered by the appointing authority. In any case, the judgment Umesh Chandra Shukla refused the application of the additional requirements since the High Court of Selection Committee did not have the power to prescribe minimum marks under the rules. Now, Subhash Chandra Marwa is an authority for the proposition that the appointing authority can choose to fix a higher benchmark while appointing candidates from the merit list, whereas Umesh Chandra Shukla is an authority for the proposition that no cutoff can be prescribed by the selection committee after the selection process started if the rules do not permit so. Therefore, it is respectfully submitted that both Subhash Chandra Marwa and Umesh Chandra Shukla operate in different factual scenarios and there is no conflict whatsoever between the said judgments. Furthermore, the judgment in Tej Prakash is similar to the judgment in Subhash Chandra Marwa, since the High Court, that is appointing authority under the staff rules, decided to employ the yardstick of minimum marks for appointment of eligible candidates, and there is no conflict between Tej Prakash on one hand and Manjushri and Umesh Chandra Shukla on the other. It is submitted that Tej Prakash and Subhash Chandra deal with Marwa deal with a situation where the benchmark is introduced by the appointing authority after the candidates are included in the select list, whereas Manjushri and Umesh Chandra Shukla deal with a situation where a benchmark is introduced by the selection committee before the candidate is included in the select list. Therefore, the principle of law that there is no indefeasible right of a candidate to be appointed applies only in case of Tej Prakash and Marwa and not in the cases of Manjushri and Umesh Chandra Shukla. In view of the above facts and circumstances, it is humbly submitted as follows. A. The judgment in Manjushri is similar to Umesh Chandra and the judgment in Tej Prakash is similar to Subhash Chandra Marwa. As a result, the observation in the reference order dated 23/2013 in Tej Prakash that Manjushri is not good law since it did not consider Subhash Chandra Marwa is misplaced. This honorable court in Manjushri has rightly considered and endorsed the judgment of Umesh Chandra and similar judgments and laid down the principle that rules of the game cannot be changed once the game has been played. Furthermore, the interpretation in Tej Prakash Patak and Manjushri laid down an absolute principle of law that in the absence of interpretation in Tej Prakash, that Manjushri laid down an absolute principle of law in the absence of minimum qualifying marks, the best candidate must be appointed, irrespective of the marks scored by the candidate is erroneous. Therefore, respectfully submit a reference to be answered by holding that Manjushri is correctly decided and lays down good law. Now, 6 Lordship had asked us to see what are safeguards which we can think of, my lord. Further, this honorable court may consider providing the following guidelines as the way forward. In a selection procedure consisting of written examination and viva, the relevant the relevant recruitment rules for selection should provide for minimum cutoff marks for the written examination, the interview and the aggregate of written and interview if necessary. B. However, if it is not feasible to prescribe minimum cutoff for every stage of selection process as a part of the rules or at the stage of advertisement notification, then 1. The minimum qualifying marks for written examination should be prescribed before the commencement of the written examination. B. The minimum qualifying marks for the Viva should be prescribed before the commencement of the Viva. And C. If the minimum aggregate marks for the written examination and Viva is required to be prescribed as a precondition for being placed in selection list, then the same should be prescribed before the commencement of the written examination.
It's a bit more.
C, my lord, sorry. C, my lord, C. In cases where cutoff is being prescribed for Viva before the commencement of the Viva, but after the written examination, then the same should be duly intimated to the candidates by way of a notification before the commencement of the Viva, and the reasons for the same also ought to be disclosed. D. Additionally, in this regard, it must be ensured that applicable selection rules empower the concerned selection authority to fix such minimum marks for written examination, Viva, aggregate of written and Viva, before prescribing the same under 6B above. If the original advertisement prescribes selection by way of written examination and Viva, under no circumstance can the process be changed subsequently to only written examination or only Viva after the selection process has commenced. Now, these are some of the safeguards which we could think of, my lord, before. Now, just two,
This is
three.
the only way you can balance the power vested with the state under the services under the state.
Yes, my lord.
Where our constitution contemplates concept of a pleasure doctrine for the purpose of appointment, which means that the state has an absolute power to determine with flexibility to pick up the best of the candidates.
Yes.
So therefore, it's not bound by the contractual relationships.
Yes.
So where such a freedom is given, it should be reflected in the selection process also.
Yes.
So, but in the selection process, if you are giving the freedom, it must not be arbitrary,
Yes.
but it can be at each stage some kind of a control.
Yes.
As you would suggest that if the rule prohibits, matter ends there.
Yes.
If the rule is not there, the silence will not do, but it must be an enabling provision.
Yes.
If it is an enabling provision, then it may do it before the written test is taken. If they want to impose a cutoff mark, they must specify it, give reasons,
Yes.
and then permit them to take written test.
Yes.
Similarly, they must follow the procedure for the oral, the Viva OC also, intimate in advance and give the reason why it became necessary to impose it. So much so that both these,
Yes.
the rights of the state as well as the duty of a state
Yes.
with the
Surprisingly, this issue keeps arising when you work on it. This issue keeps arising, and surprisingly, in large number of cases in the context of district judge selection. I don't know what the
most of the
keeps happening. Imani Malhotra, Ramesh Kumar, n number of cases in the context of judges selection.
But as experience,
Yes.
more than me, my learned brothers and Honorable Chief Justice was indicating, much of the method of picking the best will arise when you interview a
Yes.
candidate.
Yes.
Similarly, as you know, we get the best of the points when we hear you also. So therefore, one-to-one interaction.
Now, the
perhaps is the best.
the Ramesh Kumar judgment which Haripriya read, my lord, that was a case in which the advertisement specified minimum marks for the Viva. Still, this honorable court went ahead, set aside that, say, applying Manjushri on the ground that rules did not prescribe.
That's wrong.
Yes, that Ramesh Kumar, etc. were lucky because the rule says minimum Viva.
The
Still,
volunteer did the job.
Now, they applied Manjushri. Actually, Manjushri doesn't arise in that case. It is not a case of Manjushri, but still. Now, there are other judgments, my lord. For example, Manjeet Singh, which he read, my lord. Now, Manjeet Singh also, it doesn't discuss the issue in detail, but even that is a case where the petitioners were included in the select list, and thereafter they introduce this 40% for the interview. So many of these cases, my lord, with the most respect, can be distinguished by looking at what stage. At any event, selection committee, Manjushri only says selection committee cannot do that. And with utmost respect, that is Tej Prakash's reasons for doubting it may not
We
entirely.
get the point. Thank you.
Thanks, Mr. Dasan. Thank you.
After that, see if we can corner the same.
May it please, my lords. My lords, I'll keep it very, very brief. My lordship, I've handed over a small written note, my lordship, but I will not take my lordships through that. Kuriako's work is my lordship. The note is in that name.
Is this your written note is already handed over in the soft form, or this will
Yes,
be in
yes, my
addition?
lordship. It's the soft form. The previous one was there in the original.
Yes.
This is a shorter, just a 2-page bullet point kind of thing, my lordship.
Yes.
But my lordship, I will not take my lordships through most of those points because they've
Complete orally.
already been argued by my learned friends. My lordship, I only want to make 2 or 3 core
Yes.
points.
What is it? Can you formulate them?
Yes, I'll formulate it, my lordship. My lordship, my first point is that eligibility is a completely different compartment of rights, duties, and obligations as opposed to suitability. I just want to distinguish that.
No,
to the extent
Manjushri,
that-
there's no
yes,
dispute
and
on
to
this.
just- Yes.
Manjushri also
Manjushri,
clarifies
yeah,
that.
that's right.
You don't need to.
Yes. So here, my lordship, I just wanted to just take my lordship through. I won't take my lordship through the case law, but if my lordships may only look at Pawan Verma, my lordship. That is in Mr. Ansari's compilation as well. In volume 1, I would just take my lordship straight away to page 239 to paragraph 14 and 28, my lordship.
In support of what proposition?
This, my lordship, on the point of fact that the interview, my lordship, I just want to distinguish to the fact that the suitability, my lordship, at the end of the day, one of the thoughts which bothered my lordship in the last round was how do you give a certain amount of fair play at the joints? How do you distinguish or how do you bring in some level of fair play by which, like Justice Narasimha sir rightly pointed out, that pleasure doctrine, how do you give that little bit of a leeway where the suitability can be adjudged and the best of people can be taken on board? My lordship, here, just to continue with the formulation.
You're showing us some pages.
Yes.
240.
Paragraph 14, my lordship has at page 252 of the compilation of Mr. Ansari.
252.
PDF 252 only.
My lordship, this is essentially on the suitability aspect from the Justice Sikri Committee report, my lordship. I won't bother reading it out. Should I read it out to my lordship, or this is one point, my lordship, in paragraph 28.
What is the judgment you're referring, Mr. Kuriakos?
My lordship, this is Pranav Verma. Pranav Verma's judgment, my lordship. Registrar General of the High Court of Punjab and Haryana, my lordship.
Para 25.
Yes, my lordship, 20, 28 and 29, 25 I won't take it, my lordship. So my lordship has
28.
already seen that. 28, my lordship, the proposition which I want to advance is only this, my lordship. If the, yes, if,
Yeah.
As regard, may I read that, my lordship?
Yes.
As regards the petitioner's plea, the marks of the main exam should be disclosed before conducting viva. We are of the considered opinion that such a practice may not insulate the desired transparency. I'm sorry. My lordship, para 28 at page 257, my lords. Page 257, paragraph 28. Ansari's compilation, volume 1. My Lordship, Justice Roy has it. This is paragraph 28, my lords.
Yeah.
My Lordship, I'll just read from the third line. I won't take too long. My Lordship, the broad principles to be laid down in this regard must be viewed keeping in view the selection of for various categories of posts by different selecting authorities. For such a self-evolved criteria cannot be restricted to judicial service alone. If the members of the interviewing boards are already aware of the marks of a candidate secured in the written examination, they can individually or jointly tilt the final result in favor or against such a candidate. The suggested recourse, thus, is likely to form bias affecting the impartial evaluation of a candidate in a viva voce. The acceptance of the plea of the petitioners in this regard will also run contrary to the authoritative pronouncement of this court, Ashok Kumar Yadav versus State of Haryana. As the written examination assesses knowledge and intellectual abilities for a candidate, the interview is aimed at assessing their overall intellectual and personal qualities. Any measure which fosters bias in the minds of interviewers, therefore, must be done away with. My Lordship, I'll just stop there. Only to reiterate that point, my Lordship, that if the two compartments are kept separate and the interviewing board has no access to the marks which a candidate has received in the written examination, then you have a ring fence, my Lordship. There's a firewall to the extent that I will not be aware about what comes.
Normally, the interview board doesn't have the marks which are scored in the written examination.
That's right. But in some of the case law which my Lordship has seen, my Lordship will see that case law, Ashok Kumar Yadav is a case law where they've gone to that and examined the malafidis to say that yes, there is some malafide. But the challenge here, my Lordship, is when the viva voce comes in and the aggregate, the question of how do you aggregate the marks? Now, if the suitability part, my Lordship, at the end of the day, any authority needs some level of free play at the joints. Now, the free play at the joints, my Lordship, is what has troubled all these benches till date. Those rules of that game, how do you look at that 5% of that very narrow conspectus, which ultimately is where this entire litigation is centered around? That is just, in my humble opinion, my Lordship, it's a very small percentage. How do we lay down a broad kind of an interpretation by which ultimately that question can be tackled, like my Lordship pointed out, without arbitrariness coming in as a test at that stage? So how do we do it at the procedural level under the procedure established by law? My proposition, my Lordship, was to keep it both completely separate to the extent that eligibility is from a large pool of students. There could be 20,000 people applying for a job, out of which ultimately my Lordship will see that 200 or 300 finally make it for the viva.
All right. Now, what is the next point? What is the next
The
point?
next proposition, my Lordship, is to my friend Hari. I was just discussing that point, my Lordship. I would like to take my Lordship straight away to Ramchandra Iyer's judgment, my Lordship, paragraph 44. The proposition is this.
What is the point that you are making?
The point is this, my Lordship. The rule has to provide with absolute specificity, and it cannot be by necessary implication read into a rule, my Lordship. The prescription has to be absolute. The prescriptive authority, whatever is being said, cannot be assumed by silence to make the transition. So it has to be something which is absolutely certain and which can be pinned down to something which is transparent, and the rule of law should be completely tangible in that sense.
Rule must be clear and certain. Okay.
Yes, the rule must be clear and certain.
Clear and certain.
Yes,
Next.
my Lordship, the Ramchandra Iyer's judgment is paragraph
There.
44.
All right, then.
Yes, there, my Lordship, at paragraph 44, 48, and 49 are those
What is
propositions.
the third proposition?
Yes, the proposition, it may show that to my Lordship. The proposition is that the rule has to be clear, not by necessary implication. You cannot
Make the point.
bring in, yes, you cannot do something indirectly, what you cannot do directly. At the end of the day, whatever has to be done has to come in through that particular rule. My Lordship, the third point is at the end of the day, my Lordship, I won't take my Lordship through the case laws which I've enumerated, I put it there. But one of the points, my Lordship, which was vexing us while we were discussing and deliberating on this matter was also about the remedy. Where do we go for a remedy? Now, my Lordship, one of the points we very
How do you formulate it actually?
Yes.
What is the formulation?
There, my Lordship, the formulation would be this. Can some form of an ADR, I wouldn't say, my Lordship, an ADR this process, but just in terms of the guidelines which my Lordship was saying, what is possible at the end of the day in addressing these issues? One of these issues, my Lordship will see, since there's no indefeasible right, whether at some stage an ADR mechanism for each of these high courts when it comes to these kind of matters, my Lordship, because that essentially there has to be some place at which the rights can be ventilated. And these duties, at the end of the day, the rights not.
So what ADR mechanisms will the high courts follow in a competitive selection?
Public law, some kind of a provision, my lordship, in the sense that either it has to fall back ultimately in a 226 jurisdiction
Noted.
of public law.
All right. What's the last point now? Fourth point.
My lordship, the last point is again on the same principle of arbitrariness, which I won't take, my lordship. I'll just rely on my written submissions for that. The point is only to reiterate legitimate expectation as a factor which goes into these aspects before the crystallization is complete. All these points are taken. I won't trouble my.
Right, thank you, Mr. Kuriakal. Thank you. Yes, yes.
Madam, 5 minutes. First of all, my lords, I just want to clarify on the Shetty Commission report, my lords, whether it was accepted.
No, but we need not go into this.
No, on that aspect, my lords, the question is, Haripriya pointed out that that is a somewhat confusing area.
We'll not get into that at all. We've already left it to a 3-judge bench to decide.
No, my lords, no, in fact, para number 37 of Shetty Commission, which says that except those things which we have vary, rest of the report is accepted. And that report contains there can't be minimum cutoff marks. So kindly see, just referring this man, para 37 of Shetty Commission.
Okay, that is going to be decided by a 3-judge bench. So it's not.
Now, my preposition, my lords.
So you're saying that Shetty Commission has said that. Okay. We have noted it.
All second, my lords, I have already filed a written submission, my lords. That's only 3 points I have. A compilation I have filed it, my lords, yesterday. A soft copy I have filed.
Yes, we got your submission.
I have the hard copy as well with me, my lords. Please, my lords. The first, my lords, the Tej Prakash case, my lords. In fact, Tej Prakash case, I can read I'll just paragraph, so I don't want to take much of the time, my lords. So may I read this, my lords. It is respectfully submitted that answer to reference in Tej Prakash lies in Tej Prakash reference itself, which I made that, my lords, last occasion. In this contest, para number 15 of Tej Prakash may kindly be seen. This Honorable Court emphasizes that state or instrumentalities should not be permitted to tinker with the rules of the game so far as prescribing the eligibility criteria is concerned. There are 2 compartments. One is eligibility criteria, which this Honorable Court says can't be touched. This Honorable Court thereafter proceeds with the procedure for selection and doubts as to whether a more rigorous scrutiny by way of a change procedure is permitted or rules of the game can be changed. While holding so, in para 10 of this very same judgment, my lords, this Honorable Court records that power should be exercised in a manner that does not conflict with any constitutionally guaranteed rights under Article 14, 16, etc. Thus, it is observed that changing the rules of the game, either midstream or after the game is played, is an aspect of retrospective lawmaking power, which is essentially subject to the constitutionally guaranteed rights. So the Tej Prakash itself, 2 paragraphs of Tej Prakash, para 15 talks about eligibility and the suitability or the procedure of selection. Thereafter, para 10 addresses saying that there is a retrospective lawmaking power, but that is always subject to the constitutionally guaranteed or vested or accrued rights, my lords. So that is what Tej Prakash itself says. So that is my respective submission. So Tej Prakash is concerned. And second, my lords, your lordship.
Reasons.
Please, my lords.
Reasons.
Reasons. On the last occasion, during Haripriya made a suggestion and your lordship noted that there should be reasons given. The problem, my lords, all these cases, your lordship may kindly analyze all those cases, about 20-25 cases cited by both sides, my lords. Wherever there are notifications, wherever there are rules, this Honorable Court said that rules should be followed strictly. And the other batch of cases, your lordship said, of course, there is no vested right of appointment. So in such cases, so there is no interest, as again pointed out, 1350, the sequence like that. There is no vested right of appointment. Then there can be some sort of a leeway, can be there. Some discretion can be given to get the best or suitability. Then this, so far as delegated legislation is concerned, my lords, 233, so far as Kerala case is concerned, 234 rules, Article 234 rules, there is an enabling provision, as my lords pointed out. Suitability, the word suitability was there as per the suitability of the candidate. That enabling provision was there in the parent rule. That's the reason why they could frame, High Court could frame certain rules for the purpose of getting the suitable candidates. And the third, my lords, my point, Lords may kindly see this issue of there is a constitution bench judgment which is also cited and is part of the compilation, my lords. That is Ashok Kumar Yadav. That is a case from Haryana, my lords, where talks about the bias and say that you can't have there is one person interview getting 15 marks, another person getting interview 171 marks. So there is a huge gap. So whenever you are fixing an interview marks, that should be proportional, that should be minimal. In IAS examination, my lord, civil service examination, now it's 12.2, 12.5. It's brought on from 17 to 12.5. And it also says that the cutoff marks may affect the selection process. So if you fix a cutoff marks, whichever manner it is, my lords, in our selection in our society, my lords, the people who have studied in a very rural background, not able to accept themselves, my lords, an interview, he may be in a better position to express in a regional language or a hybrid English as well as regional language. But an examination like or interview before the Honorable High Court judges, my lords, for the judgeship, if the language preferred is English, my lords, some of the candidates who are practicing in a Mufussil court may be finding it very difficult to pass through, though they can express in a better manner.
Thanks, thank you, Mr. Dinesh. Yes. Anything over and above what has been argued by everyone? Point wise, yes.
Manoj, I'll just take 2 to 3 minutes. Manoj, everything is covered. I would just like to, Manoj, point out one judgment, Manoj. It is by Justice Krishna Iyer. I'll just.
What is the proposition?
Manoj,
you want to cite?
Manoj, this is again on the certainty while interviewing candidates. I'll just read out that line, Manoj, if my lords may permit me, and then I'll submit what I have to submit. Manoj, this was a case. I'll give you the.
What is the principle that certainty for the candidates while they are being interviewed?
Manoj, it basically says that whilst one person may interview somebody, the other person who interviews the same candidate, there may be different results.
Obviously, that's always so.
Now, my lords, in number of judgments, this court has held that, like even Justice Krishna Iyer holds this in this judgment. I'll just give you where it is, my lords. This is at volume 2 of the compilation, my lords, page 1107 onwards. This is Dr. J.P. Kulshrestha versus Chancellor Allahabad University.
All right.
My lords, I'm reading para 10, the last part. This court observes that certainly.
Well, just tell us the point.
This is formulated.
Your written submission
Manoj,
is already there. Just formulate.
Manoj, my submission is that in order to avoid petitions coming before the Constitutional Court, where candidates are making allegation of biasness in interview, Manoj, this court has observed number of times that interview marks should be objectively placed, and there should be guidelines, remarks about the candidates. Now, Manoj, this honorable court has adopted the medium of video conferencing to allow the entire country to participate in proceedings. Manoj, this similarly, because in 1980s that facility was not available, because that facility should be made available now for interviews, so that if any candidate is aggrieved that there is an allegation of bias, that interview should be made available, so that in essence, less petitions come to court.
Thank you very much. Thank you. Yes, now, Mr. Pawanshi.
Point which has already been formulated, I would not trouble your lordships to go again to those properties.
So tell us
I'll just put and show 2 decisions, only to point out to your lordships that how there can be, there has been a reconciliation in judgments of Manjushri, Subhashan, Marva and all. I was pointing it out on the last hearing also, that 2013 judgment of the secret judgment your lordships will find in the compilation. In my notes, what I have done is only that I have put the case laws. I given the small facts and what the proposition they hold. So I have not taken to your lordship. I'll just place 2 decisions. And so far as the facts of this case are concerned, lordship,
Mr. Pawanshi, have you given us written submission?
Lordships we have, but my written submission is not based on proposition. What Mr. Sunil Kumar Jain. Yes. Lordship may just take a note of that. That is only giving the case laws, what are the facts and the decisions, which is primarily on the fact of indefeasible right, following the Marva line of cases. So those lordships may just keep that, because
we'll keep it aside.
Keep it aside. I'll just formulate your lordships. And I just show one decision to your lordships in case if it is necessary further, but not
formulate.
Yes, I wanted to formulate this your lordships, that in a case of a selection, till the stage of preparation of a select list, if there is no change which is happening in terms of preparation of a select list, then there is no question of changing the rules of the game. But for the purpose of appointment, if there is a shortlisting of a candidate, that is what your lordships have put it, then there is no question of the principle of changing the rules of game being applied. Now, that is what your lordship has said in the Yogendra Yadav also, that till the
Look at your submission.
no, lordship, it's not on the proposition. So,
Point, as you're saying.
yes, your lordship.
Your
the
para
question
two, you're
of-
saying.
yeah.
It is a submission of the petitioner that one principle which has been settled is that mere inclusion of name of a candidate in the select list
Yes.
does not confer on such candidate any vested right to get an order of appointment.
Yes.
And Shankar Sen Das you have quoted, which
Yes.
we saw the other day.
Yes, your lordship. That's the. Then I have put down the judgments, Shankar Sen Das, and then Subhash and Marwa. I have just put it to the bullet points. And then the decision in JPSC. This was a case where for paper 3, there was no cutoff marks. That's paragraph 5, if your lordship would see. Lordship are looking at my submissions of 13th of
Para
July.
5, yeah.
Para 5. This is a case of JPSC. There was no cutoff marks prescribed for paper 3. The cutoff marks was prescribed later of 60%. That was upheld by our lordships. They say that Roman 3, this is not a change brought about, but an additional aspect brought in while determining the merit of the candidate. So JPSC case was where 60% cutoff was put for paper 3, there was no cutoff. Lordships have approved it, and the reasoning given was Roman 3, that this is not a change brought about, an additional aspect brought in while determining the merit of the candidate who found fit to be eligible for consideration of appointment as lecturers. Then paragraph 6, I just quoted the judgments.
JPSC, because they say if you
CD, is it?
so 3 judges.
It's 2 judges, your lordship.
Judges one.
JPSC is a 2 judge judgment.
So
This
you're
kind of inconsistency, lordship will find in.
So, Pawanji, how do you formulate if you can make
Yes,
your
so-
submissions 2 or 3 points,
Yes,
give us your best point.
Yes, so lordships, I was not trying to pull out the way the JPSC has done. My submission to your lordships is this, that when till the stage of a preparation of a select list, the criteria which has either been fixed by the advertisement in terms of the rule, till the time there is no change in the preparation of the select list by changing the criteria, the principles of changing the rules of game will not apply. So,
No, come again. I didn't. Why? It will necessarily apply.
no, lordships, I am saying
Select list
till the stage of
is after an advertisement. After that, if it is a prescription of a written examination,
Yes.
it's a written
Plus
exam.
Viva.
yes, lordships.
Thereafter, a viva.
Yes,
And after that,
a select
comes
list.
the select list.
Yes, till the stage of preparation of the select list,
Yes.
they can't, the principle of changing the rules of the game will apply. That is what my
Will
submission is.
apply.
Will apply.
You are saying it will not apply. That's right. Okay,
No,
will
it will
apply.
apply.
Will apply.
It
All
will
right.
apply. So, like many cases,
You get
where
the
the
point. So, what's the sequitur?
post that, like in what we have seen in Marwa, for the purpose of shortlisting or appointing the candidates, at that stage, there's no question of having an indefeasible right, and where the criteria can be fixed either to select the top or fixing a the minimum or a maximum qualifying or a minimum qualifying mark at that
Then the
stage.
question is arising before the select list stage itself.
Right.
as in Manjushri and so on, before the select list,
Lordships.
all of a sudden, without intimation,
Lordships, right.
a cutoff mark is imposed. So
Lordship.
therefore, the question arises: can that be done or not?
Yes. So my
What's your answer?
in terms of the proposition of law, in terms of that principle in Manjushri cannot be said to be incorrect because 25% fixation at the stage of putting a cutoff.
So you are saying that, well, up to the point that a select list is notified,
Yes.
you can't change the rules of the
Yes,
game.
because until that time, because you're not disturbing the merit
He
list.
is right.
Because you are not disturbing the merit list in any manner, because you are following what.
After the select list is prepared, then at the stage of giving appointment,
Yes.
you can say that, all right, I'm going to take the top 5
So
candidates.
like in Marwa, what has been
What's your
done,
point?
the select list has been prepared. Then they said, I'll take 55% and above. Similarly, in the case of Rajasthan, after the selection of prepared select, because that is not,
55%.
because there is no disturbance of the inter se merit which has been finally fixed at the stage of select list. That is what my proposition. The one judgment.
The assessment of merit has been made on the basis of the notified criteria.
Yes,
And that is the basis of the
that is the
select
basis
list.
of selection.
And once the select list is prepared, then the employer is thinking,
Yes.
I'll take the best 5,
Best of the
or I'll take
Yes.
those who have gone beyond this particular line.
That is what my submission would be.
And the employer is abiding by according to the inter se merit.
Inter
They're
se
not
merit.
taking somebody lower down
Yes.
and excluding somebody
Yes,
higher
Your
up.
Lordship. At that stage would be my submission as for submitted by at that stage also you still impose condition to say that you should not still do on an arbitrary basis. That's a different thing that you select 1, 5 and 7 as was suggested, not in that. But in terms of merit, if there is a cutoff being fixed, then there is no question of further questions being asked whether you have done it on some basis or not. That stage should not be there because that was another proposition that should be an exception. Till the time I'm not disturbing the merit list, there's no question of me being put to any, as an employee being put to any restriction that I'm not
Thank
selecting.
you, Pawan.
So only one judgment. This is the broader formulation to your lordships. Rest your lordship already seen as a proposition. Just one judgment I was trying to cite in the last occasion also.
Which is that judgment?
It's a judgment of just Yogendra Yadav. It said 2013-14 SCC 623. In fact, this is exactly the same.
Small order, obviously.
It says, but it says 2013-14 SCC 623, paragraph 13 and 14.
What's the principle you are relying on?
It's in the compilation volume.
It doesn't matter, we'll pick it up. What's the principle you are relying on?
Paragraph 13 and 14, the same principle which I was suggesting to your lordships.
How do you formulate it? What do they say actually?
They say that what is done in the instant case is that a decision is taken to give appointment only to those persons who have secured 70% marks and above marks in the unreserved category and 65% marks above marks in the reserved category. In the absence of any rule on this aspect in the instant case, this does not amount to changing the rules of the game.
This is Marwa. This is Marwa.
But in this case, your lordships, there was a criteria of 80% marks of 50% marks in the written examination, and there was also a cut of qualifying marks in the interview. After the selection, which has happened, a select list was prepared. Then they again fixed the criteria.
So decided to, therefore, in other words, not select everybody, appoint everybody who was in the selection.
So the Umesh Chand Shukla's principle that after the select list is finally drawn, still you cannot do to 600 is what I'm saying should not be treated to be as a correct principle.
All right. Thank you. Thank you.
Thank you.
Yes, Mr. Ansari.
Just Just on facts, in my case, Rajasthan High Court Lordship has already taken a decision. Since my learned friend was referring to the facts, I'm not taking a tribunal lordship on that because otherwise there will be different. Because Lordship has already taken a decision on that.
Mr. Ansari, everybody has written piggyback on your compilation.
I will rely on my submissions, my lord. My lord, there are 3 or 4 my lord, very important issues as per lordship's consideration. Right. First is, my lord, whether a minimum cutoff can at all be fixed for the interview.
We will not get into that.
No, because
minimum cutoff
cutoff for the interview can be fixed even in the rules or by an executive order before the starting. Can it be fixed in the advertisement? Because, my lord, submissions have been made. Shetty Commission says it should not be done. That's recommendation.
We are not going to the specifics of.
No, I would humbly request your lordship, lord, to kindly, because the bench of 5 honorable judges, we are not going to get it, my lord. And this issue has been debated before, lordship.
No, it's
I will
not been
humbly
debated before us.
We have
and
not
that
really
is not
heard
the
them
correct
out.
No,
path to
it
do
has
that.
been argued, my lord, that the SETI commission has said so. It has been accepted by the SETI commission.
Just in passing, but we have reserved, we have set down those matters before a 3-judge bench.
Yes, my lord.
So for us now,
Very
to,
well,
know
Lord.
the absence of that.
I thought
It's
that
not
no,
that
that
at
is
all.
an issue where your lordship may say SETI commission recommendation is not correct. And all India judges is
We will
3
not
judges.
touch that issue at all.
I'm so sorry, my lord.
The reference does not involve that. We will
The
not
reference
touch
does
that.
not involve
So
that,
therefore,
but
we
then
will not touch it.
Very well, my lord, very well.
Good.
Now, the second issue is, my lord, whether there should be, my lord, a change in the rule of game. That is what the reference is, my lord. What is the change in the rules of game, my lord? My lord, we are all dealing with the selection process of the judiciary, my lord, mostly in the higher judiciary, where a sitting judge, my lord, of the High Court, my lord, makes the selection process. Now, my lord, if the selection committee, if the rules are there, it can be in the rules, my lord, because if your lordships are not going into it, because some of the submissions are there, it cannot be even in the rules. It can be in the rules, my lord. My submission is because, my lord, the importance of the interview, my lord, Justice Chinnappa Reddy and Liladhara said, my lord, it's very important, which has been followed, my lord, into 2 subsequent judgments. One by the 4 judges, my lord. The Ashok Kumar Yadav is not 5 judges, it is 4 judges. With your lordships, will
Formulation, can you just sort of formulate 3 or 4 points and then we can sort of.
my lord, I have formulated in my 6-page submission, my lord, if
All
your
right,
lordships
okay.
kindly have it there.
All right, let's look at let's look at your submissions then.
Yes, my lord. If your lordship see my submission filed on behalf of State of Manipur, on the first day, my lord, I invited your lordship's attention to the 6-page submissions, my lord. I read to your lordship, my lord, the questions. May I will send it to July 2023.
All right, let's look at your 6-page
Yes,
submission
Lord.
so that.
Yes.
Yes.
You have formulated questions in para 1. You can skip that.
Yes, my lord. Let me go, my lord, para 2 onwards. my
Para
lord.
2.
My lord, this is Mukhtar.
Just that we can skip
Yes.
because we are not going to deal with it.
Come to para 4 actually.
Yes, my lord. Para 4, my lord. May I read that? It is submitted that the written examination assesses a candidate's knowledge and intellectual ability, whereas Viva Voce evaluates the candidate's overall personality, including alertness, clear and logical presentation, effective discussion, ability to judge, and take decisions. Lord, this is what has Liladhar said. Lord, I have put it as by my submission.
Yes.
Statutory rules framed under Article 209 read with 233 to 234 can prescribe minimum qualifying marks for both written and viva. A candidate cannot be allowed to contend that prescribed qualifying marks for the written and viva is illegal and arbitrary and constitutionally impermissible. Both written and viva serve different purposes in the selection process. Though SETI Commission in his report has suggested there will be no cutoff for viva, this issue has not been gone into by this honorable court in all India judges, that is 3 judges, my lord. Prescribing cutoff marks for the viva in statutory rules is a valid requirement of selection process and cannot be faulted. The importance of, my lord, the viva has been, my lord, dealt with in Justice Chinnappa Reddy's judgment, my lord. May I read just 2 paragraphs of that judgment? The importance, not very well, my lord.
Go to para 5 now, I think.
Yes, my lord. May I now go to para 5. The cutoff marks for both viva can be prescribed in the statutory rule. In the absence of any prohibition in the rules, it can be done by an executive order at any stage before the commencement of the viva. Such cutoff marks can be fixed even after advertisement, so long as there is no allegations of malafide or favoritism. The pronouncement of this honorable court that the cutoff marks for viva cannot be fixed at a stage later than the issue of advertisement at amounts with change of the rules of the game midway, and the selection process does not lay down the correct law. Because why I'm saying this is this, my lord. If, my lord, the selecting body finds, my lord, in a given case, there are 10 posts, my lord. There are 1,500 candidates who are eligible, my lord. Can it not say, my lord, we will interview only those who comes within a particular range, my lord? It can, my lord, because the whole purpose of interview, otherwise, my lord, in the Ashok Kumar Yadav, they have found you have to interview thousands of people. So, my lord, unless malafides are there, unless you pay, it is to favor someone. Or my lord, there's some suspicion because in the Punjab case there was something, my lord, Justice, this honorable court appointed Justice Sikri to go into it, reevaluate entire thing, my lord, and then gone into it. My lord, then there are cases and cases, but as a basic principle of law to say that you can never do it, my lord, is not a correct proposition of law in my respectful submission.
Right.
And there are 4 or 5 judgments, my lord. I have given the para numbers and I have given the court has seen that. Now, my lord, another submission is made, and my learned friend Dinesh also, my lord, that you cannot fix the proportion. You cannot have very, very high. But it all depends on the service to service. Lord,
we will not fix an
there are some submissions that have been made on the other side because Ashok Kumar Yadav said it cannot be more than 12%.
We're only checking the principle.
My lord, here your lordships no. So what in settling the principle, what I want your lordships to kindly consider and say that it depends on the service to service, depends on the appointing authority. In a high court, my lord,
can't be a hard and fast rule.
no hard and fast rule because they want that as Ashok Kumar Yadav, there's an observation, it cannot be more than 12%. My lord, that is a 4th and that's not the correct principle. That is a passing observation. So that's what I say. Proportion of marks between the written and the viva varies from service to service according to the requirements of the service. It must be left to the appointing authority to prescribe the proportion. This court is not equipped to pronounce upon a uniform pattern of proportion to be maintained between the written and viva. Similarly, cutoff mark for both written and viva for the purpose of must be left to the appointing authority. Under the Manipur rules, my lord, I have said it is, my lord, 16% and prescribing 40% for viva is valid. Then again, my lord, I have given certain judgment, my lord.
We'll look into it.
The third is, my lord, my lord, I'm so sorry.
Yes, we'll look into it.
Yes, my lord, para 7. Now, my lord, disclosure of marks, my lord, to the interview board, my lord. Now, my lord, today, my lord, we are debating, my lord, where the honorable judges who are conducting the interviews, my lord, would be biased. My lord, I'm so sorry. Would be, my lord, it should be disclosed or not. There are 2 judgments.
According to you, they shouldn't be disclosed.
It should not be disclosed, my lord, normal course, my lord. But then to doubt it, my lord, merely because it is disclosed, there would be malafide, there would be first. But we know cases, my lord, where the selection of the higher judiciary is made. I'm aware of, my lord, a district judge being appointed only on asking 2 questions. How many children you have? Would you survive on this salary? Or like, when do you want to join? Look, that is the state, that is the level of confidence we have in the selection committee when it is, otherwise the whole purpose is, my lord, having a high court judge or having a senior nominated by the chief justice at the head of the selection committee to say, my lord, that there would be malafide, there would no, we cannot.
So, thank
so
you,
that is
we look
third,
at
my
your
lord.
submissions
And-
and your cases also.
And my lord, last, lordships are concluding this,
Yes.
just give me 2 minutes, my lord. The last is, my lord, regarding point number 8, that no indefeasible right, my lord, to appoint.
That you have said,
That your lordship has, that is the, my lord, Constitution bench judgment in 1991, and finally by my lord, the chief justice judgment in, my lord, 2020, which is there, my lord.
Lordship, I'll just mention one thing regarding this, Lordship. The doctrine under Article 310 does not apply at the recruitment level. It applies only post-recruitment.
Yes, sir.
Since the crucial words.
Thank you very much on both the sides. Now, thanks to all the council. Thank you very much for formulating. Thank you.
My lord,
Thank you.
My lord, for the Union of India, learned ASC was there. If my lord, he can submit his note.
He can submit his note, yes. Nataraj, ask Mr. Nataraj. He'll come.
Please.
marks in aggregated 75 is arbitrary, violative of 14 and
motor vehicle category. While the councils have referred to various other provisions of this act and the rules,
Guidelines, when the selection process has to happen in different stages, what would be the criteria required to be adopted on that I have highlighted?
Thank you, Mr.
I'm grateful.
But I appear.
Which is the reference order, and pursuant to your lordship's direction, my lords, on Thursday, I have circulated in my matter a comprehensive note, which is there on your lordship's, I'm sure it's placed on your, that I have placed it. The learned Solicitor General, my lords, who appears for Oriental Insurance Company, has also filed his written submissions, my lords, as far as these two matters are concerned. I'm not sure about the others, my lords, what they filed. In all, there are 76 matters before your lordships on board. So the lead matter is mine. The learned solicitors is Oriental Insurance Company's matter, my lords. And he's on screen, and Mr. Bhushan is there. And I think Mr. Kaul is for an intervener.
Let the lead matter start. I have no.
So we, all right. So we'll, Mr. Dave, you are in the lead matter, right? So you can start there.
I had appeared, my lord, in the reference by 2 to 3 and by 3 to 5. I am in 502.44, 45 and 46. I had appeared at the stage when it was referred by 2, doubting Mukul Devangan, and then at the stage of 3, doubting Mukul Devangan again and referring to 5. Whichever way your lordship wants, so we can.
So we can start. Should we start with the first matter? We'll start with the first matter and then hear them here and see, let them whoever is.
May I request your lordships to take the written submissions? The issue is quite a narrow one, my lords.
Balaji and Sampur.
What is before your lordships, my lords, while your lordships are locating, is a reference of a 3-judge bench, my lords.
So should we go first to your submissions?
Yes,
or?
it will be convenient, my lords, for your lordships, my lords. Just page 3 of my submissions, if your lordships have. It has a reference timeline for convenience purposes, my lords.
What do you want us to do?
My written submissions at page 3, my lords. I've set out the issue, my lords, in para 1.1. I filed a comprehensive written submission. It has all the judgments in it, the reference orders, and even the earlier 2-judge bench orders, which were doubted in the first round itself. If it comes to it, my lords, they are all before your lordship.
You are referring to the final written submissions.
Yes,
that's what it says.
Yes.
886 page.
Yes, no, that is.
Is it 886 page? Okay.
Yeah.
Because I put the Motor Vehicles Act also now, since we have digital, so and the rules as well on this.
For broad written submission.
Yes, my lords. There is an index, my lords.
Judgments.
Index divides into A, written submissions,
Bookmark.
Violation
of judgments.
Yes, my lords.
And then C, Motor Vehicles Act.
Yes, my lords. My two colleagues from my office, my lords, were more adept at this than I am. And I'm grateful to them for doing this, my lords. But I've set out the issue that is there before your lordships, and it's in a narrow compass, and it is, my lords, whether a person holding a driving license in respect of a light motor vehicle could, on the strength of the said license, be entitled to drive a transport vehicle of light motor vehicle class, which has an unladen weight not exceeding 7,500 kilograms. Before para 1.2, my lords, your lordships may just see the reference timeline, which is tabulated in the form of from 2016. There was a reference by 2 honorable judges, my lords, in Mukund Devangan, which noticed the conflicting views in 8 judgments of this honorable court and referred inter alia the issue of whether the holder of a license of a light motor vehicle is competent to drive a transport vehicle to a bench of 3 honorable judges. In 2017, my lords, the reference was answered and the judgment in Mukund Devangan was delivered by 3 honorable judges, my lords, which answered the reference, concluding that the holder of a license of a light motor vehicle is competent to drive a transport vehicle not exceeding 7,500 kilograms without a separate endorsement on the license to drive a transport vehicle. This 3-judge bench, my lords, was again doubted by 2 honorable judges, my lords, in 2018, which noted that the submissions of the council that the judgment in Mukund Devangan did not consider significant provisions of the Motor Vehicles Act. Accordingly, the bench directed that the matter be placed before a bench of 3 honorable judges of this honorable court. Then comes the reference, my lords, in 2022 to your lordships, my lords, which is on 8/3/2022, which concluded that the judgment in Mukund Devangan did not notice certain provisions of the Motor Vehicle Act requiring the judgment to be reconsidered, and the bench was pleased to opine that being a combination of 3 judges, it was appropriate to refer the matter to a larger bench. Accordingly, the present matter has been placed before the Constituent. Because I may request your lordships, my lords, before I go to Mukund Devangan, what it holds, my lords, can I just show for convenience sake what your lordships were pleased to refer, my lords, by 2 honorable judges in 2018. Because after all, it's a judgment of 3 honorable judges. Ordinarily, it is binding on 2 honorable judges. So that your lordships will get.
That is 2016 for SCC 298, right?
This is 2018, my lords. 2000. No, this is the reference I'm referring to. This is page 110, my lords. If your lordships are pleased to turn to page 110.
PDF?
100 and PDF. PDF is the same.
Yeah.
It starts at 104. Oh, sorry, 110. Sorry. No, 1 second. I'm going to the.
Yeah,
sorry, my lords, I'm going to the 2 judges. Sorry for the confusion. So after Mukund Devangan was delivered, my lords, your lordships at 104 and 106, sitting in a combination of this honorable, sitting in combination of 2, my lords, at 106, were pleased to hold this at 106. Whether a person licensed to drive a light motor vehicle is ipso facto entitled to drive a transport vehicle in that category is the question to be considered in these cases. We find that the issue has been considered by this court by a bench of 3 judges in Mukund Devangan, reported in 2017 for SCC 663. The conclusions in Mukund Devangan are summarized by the court and reads as follows, para 60. Thus, we answer the question which are referred to us thus. 60.1, light motor vehicle as defined in section 221 of the Act would include a transport vehicle as per the weight prescribed in section 221, read with section 215 and 248. Such transport vehicles are not excluded from the definition of light motor vehicle by virtue of the Amendment Act 54 of 1994. A transport vehicle and omnibus, the gross vehicle weight of either of which does not exceed 7,500 kilograms, would be a light motor vehicle and also a motor car or tractor or a road roller, unladen weight of which does not exceed 7,500 kgs and holder of a driving license to drive class of light motor vehicles as provided in section 10(2)(d) is competent to drive a transport vehicle or omnibus, the gross vehicle weight of which does not exceed 7,500 kgs, or a motor car or tractor or road roller, the unladen weight of which does not exceed 7,500 kgs. That is to say, no separate endorsement on the license is required to drive a transport vehicle of light motor vehicle class as enumerated above. A license issued under section 10(2)(d) continues to be valid after amendment of 1994 and 28/3/2001 in the form. The effect of the amendment made by virtue of section 54 of 1994 with effect from 14/11/1994 while substituting clauses E to H of section 10(2) which contain medium goods vehicle in section 10(2)(e), medium passengers motor vehicle in section 10(2)(f), heavy goods vehicle in 10(2)(g) and heavy passengers motor vehicle in section 10(2)(h) with expression transport vehicle as substituted in section 10(2)(e) related only to the aforesaid substituted classes only. It does not exclude transport vehicles from the purview of section 10(2)(d) and section 241 of the Act, light motor vehicle. The effect of amendment of Form 4 by insertion of transport vehicle is related only to the categories which were substituted in the year 1994, and the procedure to obtain driving license for transport vehicle of class of light motor vehicle continues to be the same as it was and has not been changed, and there is no requirement to obtain separate endorsement to drive transport vehicle. And if a driver is holding license to drive light motor vehicle, he can drive transport vehicle of such class without any endorsement to that effect. That is what your lordships held in 3 judges. Then the 2 honorable judges were pleased to hold that it is the submission of Mr. Bhushan and Joy Basu, learned counsel, that the certain distinct provisions pertaining specifically to transport vehicle have unfortunately not been brought to the notice of the court. Section 4(1) of the Motor Vehicles Act, hereinafter referred to as Act, provides that the minimum age of holding a driving license for a motor vehicle is 18 years. Section 4(2) provides that no person under the age of 20 years shall drive a transport vehicle in a public place. Section 7 provides that no person can be granted a learner's license to drive a transport vehicle unless he has held a driving license to drive a light motor vehicle for at least 1 year. Section 14 deals with the currency of license of driving motor vehicles. A driving license issued or renewed under this Act, in case a license to drive a transport vehicle will be effective for a period of 3 years, the proviso to section 14(2). Sorry.
Yes.
I was reading para 3. Section 14 deals with the currency of license to drive motor vehicles. A driving license issued or renewed under this Act, in case a license to drive a transport vehicle will be effective for a period of 3 years. The proviso to section 14(2)(a) provides that in case of a license to drive a transport vehicles which come in the light motor vehicle category. While the councils have referred to various other provisions of this Act and the rules, we have only referred to a few very significant submissions. Since the prayer is for reconsideration of Mukund Devangan, we are of the view that it is only appropriate that the prayer itself, in the light of some submissions we have noted, be considered by larger. Which is dated 8/3/2022. To which my Lord Justice Narasimha was a party, my lords, at page 113. This also culls out, my lords, and quotes in para 2 the judgment of Mukund Devangan. I'm not reading that, my lords, since I've already read it. And thereafter, my lords, at page 115, your lordships were pleased to quote the judgment I have already, the order that I read, my lords. And then page paragraph 3, 4 are also what has already been noted by your lordships, my lords. And then paragraph 5 is the reference order at page 116, my lords. Having bestowed our attention to the contentions raised by the learned counsel and the issues which fall for consideration, in our view, the referral order was right in stating that certain provisions were not noticed by this court in its decision in Mukund Devangan. We are prima facie of the view that in terms of the referral order, The controversy in question needs to be revisited. Sitting in a combination of three, we deem it appropriate to refer the matter to a larger bench of more than 3 judges, as the Honorable the Chief Justice of India may deem appropriate, and therefore the matter comes now, my lords. There's one part, my lords, para 7, I would like to read for your lordships, my lords, because that depends on individual facts, what your lordships in a combination of 3 were pleased to hold. Para 7. Before we part, we must note that all the learned counsels appearing for the insurance company have fairly submitted that the compensation in terms of the directions issued by the courts below, that is to say, in following the principles laid down in Mukund Devangan, has either been paid in full or shall be paid in terms of such direction. Their statements are recorded. So as far as individual cases and compensations were concerned, my lords, we were told to comply with that.
This one.
Sorry, I'm so sorry.
With us.
Yes.
Sorry.
Getting 3, I think we get 2. License is necessary.
License is necessary.
Who is the other side who's going to say it's not necessary? Who are appearing?
We actually we are for the claimant, because Malasha, whatever be the consequences, it will be for the claimant with respect to the entitlement of compensation from whom? Because like the whole intention was to actually safeguard the claimants, poor claimants across the country, my lord. So
you are supporting Mukund Devangan basically.
Yes, my lord. Yes, we are supporting Mukund Devangan because like the pay and recovery has to be ordered.
All right.
But there is no breach of policy condition. All the submission.
Yes, yes. So there are somebody's in contest that we require
Yes,
some assistance on this side. Yes.
So that's page 4.
Supporting your.
Yes. Solicitor is appearing for Oriental Insurance Company. Oriental Insurance.
He is insurance company.
Then who is for the union?
Because it arises out of an insurance claim.
Union is not a party, my lord.
Since it's a pure insurance claim.
Again, across the country.
Lordship, please. At page 4, my lords. No, the imbalance, that's why your lordships were pleased to direct us to pay.
We'll balance it from the.
So your contention is the fact that you have a license to drive a light motor vehicle.
Yes.
Does not entitle the person to drive a transport vehicle, albeit in the light motor vehicle class.
That short is.
There are 2 different classifications. Rules deal with both separately.
Yes. And why I'm asking you lordships to come to the chart is because what Mukund Devangan did was.
As a specific section, it says that you will drive a class of vehicle which your license authorizes you to. But if you want to drive a transport vehicle, your license must specifically say.
Oh, I see.
The whole scheme is like this.
So it's not, there's not a case of silence of the statute, but as. Yes.
So if your lordship says page 4, it defines light motor vehicle. And this is the problem why it comes, my lords. And which I'll refer to as LMV, since everywhere it is referred to as LMV. Light motor vehicle, which is defined under 221, means a transport vehicle. And then I've given the definition of transport vehicle in red, my lords, which is under 247. It means public services vehicle, goods carriage, educational institution, bus, private service vehicle, or an omnibus, which is defined under 229, which means any motor vehicle constructed, adapted to carry more than 6 persons, excluding the driver, the gross weight of which, my lords, and the gross weight is total weight is defined under 215, or means a motor car, my lords, which is defined under 226, tractor, road roller, and then comes the unladen weight of which does not exceed 7,500 kilograms. So the definition of an LMV, my lords, is a transport vehicle, omnibus, the gross vehicle weight of which, or motor car, tractor, road roller, unladen which the weight of which does not exceed 7,500.
So a light motor vehicle could also be a transport vehicle.
Yes, it could be. It could be.
Yes,
it could be.
That's the point.
It could be even a road roller.
Right.
Usage. Then, my lords, this 10.2 I have set out in part. 10.2 provides for the classes of vehicle which we are concerned with. I have set out. Transport vehicle is a separate category, and light motor vehicle. In the asterisk, my lords, I have mentioned that it also covers other classes of vehicles such as motorcycle without gear, motorcycle with gear, adapted vehicle, road roller, motor vehicle of a specified description, which your lordships are not concerned with. What in brief Mukund Devangan says is, my lords, that since what fell from your lordships, transport vehicle entitles you to drive, an LMV includes a transport vehicle, if it is 7,500 kilograms, and you have a driving license to drive a light motor vehicle, you do not require any other endorsement in your license or any special permission.
Because it postulates, it proceeds on the basis that the statutory definition includes a transport vehicle in the definition of light motor vehicle.
Now, what Mr. Bhushan, what he pointed out, my lords, if your lordships, if it's bookmarked, I've set out the act, or if your lordships have the bare act separately, at page 315 of the compilation. Otherwise, if it's more convenient, then
that's okay. We got the act as well.
Yes, I put 315. Unfortunately, I put the act itself, my lords.
Chetan, आज हम सारी
Sorry, my lords.
But now that you've given us the page, we are
getting bookmarked.
Sorry, that's my 315. It starts at.
So, Mr. Dave, your iPad now is in general for your practice, or is it only in the Constitution bench?
Not on miscellaneous days, because rushing in a court and just grabbing something, the file when it comes to turn quickly, I'm still getting used to it. Though Ms. Pathak has been kind enough to give me some tutorials as to how even that can be done quickly.
Faster, even
much faster.
I know, I'm gravitating towards it now.
One brief in hand for all the courts.
Yes, that is true.
Even better.
She was saying, my learned friend was mentioning that no clerk, no juniors, just you yourself are like the old Bombay lawyers. I believe carry your own file.
Yes.
Well, it's 315 if your lordships have. And before I take your lordships to the definition in, again, there is one section which is section 3. And much turns on this section 3 at 319, my lords.
Mr. Bhushan, you don't have your iPad. Yes.
But he also has a book.
The book I got because I was finding it hard to find the amended.
The amended version.
So This is difficult to, because this was amended in 2019 and all the area code, etc., all have to be in 2016.
Well, the rule should be whichever senior doesn't use an iPad, it will dock him like a penalty in cricket or in tennis, 50% of his fee. Plus 319, section 3. Now this, according to us, Manoj, is the most important section, which ought to have been, it is noticed in Mukund Devangan, but not dealt with in our respectful submission. Now please see this. This deals specifically with the necessity for driving license. And it reads, Manoj, if your lordship permits me. Necessity for driving license. No person shall drive a motor vehicle in any public place unless he holds an effective driving license issued to him, authorizing him to drive the vehicle. And there's a semicolon. So you can have no person shall drive a motor vehicle in any public place unless he holds an effective driver's license issued to him, authorizing to him. And no person shall so drive a transport vehicle. I'm skipping the bracketed part, Manoj, for the time being. Shall so drive a transport vehicle unless his driving license specifically entitles him to do so. The bracketed part are, Manoj, which are by way of amendment, other than a motor car, cab or motorcycle hired for his own use or rented under any scheme made under subsection 2 of section 75. These includes, Manoj, when we travel to Goa and all, we rent a car or something for our purposes. So that includes this part. But otherwise, after the semicolon, Manoj, and no person shall so drive a transport vehicle unless his driving license specifically entitles him to do so. So one, you require a general license to drive, hold an effective driving license issued to him, authorizing him to drive, which is the first part, Manoj. And the second part is specific to a transport vehicle. And his license, driving license, has to specifically entitle him to do so. As I said, Manoj, this part has not been dealt with in Mukund Devangan. And it is our contention that if were you to drive in the scheme of the Motor Vehicles Act and the sections that have been referred to by your lordships in the referral order, transport vehicle falls under a separate category altogether. And that becomes clearer if your lordship then goes to the next section, which is section 4. Age limit in connection with driving of motor vehicles. No person under the age of 18 years shall drive a motor vehicle in any public place. So it is further qualifying what is said in section 3, my lords, that no person shall drive. So that person has to be above 18 as per in regard to as per section 4. Yeah, I'm coming to. I'll read the whole, my lords. I'm not skipping any part. Provided that a motorcycle with engine capacity not exceeding 50 cc may be driven in a public place by a person after attaining 16. 2. Subject to provisions of section 18, no person under the age of 20 years shall drive a transport vehicle in any public place. So there is one qualification which is in 3. Then comes a further qualification in 4. So 18 for vehicles generally, but if it is a transport vehicle, it requires the person to be 20 years of age to drive a transport vehicle in a public place. So that distinction comes once again, my lords, between a motor vehicle holding an effective license and then a transport vehicle. So you have to be 20 years of age. Now, 5 is responsibility of the owners, my lord. No person shall be in charge of a cause permit to drive, my lords. And then it comes, my lords, to 7, my lords, if your lordships has. Restriction on the granting of learner's license for certain vehicles. no person shall be granted a learner's license to drive a transport vehicle unless he has held a driving license to drive a light motor vehicle for at least 1 year. But straight away a distinction is drawn by the legislature. So if everyone requires a learner's license, so no person shall be granted a learner's license to drive a transport vehicle unless he has held a driving license to drive a light motor vehicle for at least 1 year, provided that nothing contained in subsection 1 shall apply to e-cart, e-rickshaw. No person under the age of 18 years shall be granted a learner's license to drive a motorcycle without gear except with the consent of the parent. So first distinction is in 3, my lords. The second part of 3 specifically entitling him to do so. Second comes in the age limit of 20 years. Third is in the learner's license that you already require to hold a light motor vehicle license for 1 year before you can be granted a learner's license to drive a transport vehicle. Now, my lords, 8 is grant of learner's license. Any person who is not disqualified under section 4 I read to your lordships, my lords, dealt with the age limit. Any person who is not disqualified under 4 for driving a motor vehicle and who is not for the time being disqualified for holding or obtaining a driving license may, subject to the provisions of section 7, apply to any of the licensing authority of the state. One in which he ordinarily resides or carries on business, in which the school establishment referred to 12 where he intends to receive instructions, or for the issue of learner's license. Every application under subsection 1 shall be in the form and shall be accompanied by documents which with the fee including may be prescribed. Every application to drive a transport vehicle, that is subsection 3, minutes, under subsection 1 shall be accompanied by a medical certificate in such form as may be prescribed by the central government and signed by such registered medical practitioner as the state government or any person authorized in this behalf by the state government may by notification in the official gazette appoint for this purpose. So, my lords, even for a learner's license, apart from him holding a license for 1 year, a learner's license for 1 year to drive a light motor vehicle, further has to provide, my lords, that is a medical certificate in the form that has been prescribed by the central government and signed by a registered medical practitioner. Now, my lords, 5 says, no learner's license shall be issued to any applicant unless he satisfies such conditions as may be prescribed by the central government. Will come to the rules, my lords.
Subsection 4 applies only to subsection 3, is it?
Yes, my lords. Sorry, I skipped that, my lords. If from the application or from medical certificate referred to in subsection 3, it appears that the applicant is suffering from any disease or disability which is likely to cause the driving by him of a motor vehicle or such of the class which he would authorize by the learner's license applied for to drive to a source of danger to the public or the passenger, the licensing authority shall refuse to issue the learner's license. Yes, no. So this is on learner's license, my lords. Then your lordships may have (9)(4), my lords, again draws a distinction. Where there's grant of driving license, any person who is not for the time being disqualified for holding or obtaining driving license may apply to. And 4, where the application is for a license to drive a transport vehicle, no such authorization shall be granted to any applicant unless he possesses a driving certificate issued by a school or establishment referred to in section 12. Other things, my lords, about the habitual criminal, etc., we are not concerned with. Then comes 10. Now, 10 is where your lordship's judgment in Mukund Devangan interpreted that if you have for light motor vehicle, then transport vehicle is a separate category. You can drive a transport vehicle if you hold a license for light motor vehicle. Now, form and contents of license to drive. Every learner's license and driving license, except a driving license issued under Section 18, shall be in such form and shall contain such information as may be prescribed by the central government. A learner's license, or as the case may be driving license, shall also be expressed as entitling the holder to drive a motor vehicle of one or more of the following classes, namely a motor vehicle without gear, a motorcycle with gear, adapted vehicle. D is light motor vehicle, and E is transport vehicle. F is road roller, and J is motor vehicle of a specified description. This earlier had other 4 other classes, my lords, which were amended in 1994. And in their place, this transport vehicle came, and light motor vehicle existed, but all other categories after that were now have been subsumed in transport vehicle. So Mukund Devangan, my lords, your lordships interpreted that since light motor vehicle is by a class, the definition of light motor vehicle includes a transport vehicle up to 7,500. You don't require a separate endorsement to drive a transport vehicle. But what you didn't notice, my lords, I'll go to the other sections also, since we are on going seriatim, my lords. 10 is this part. Now your lordships will kindly.
A section which authorizes or the one which grants the license.
No, this is only
10 is actually speaking about what should the license contain as the ingredients, as against the grant which falls under 9.
Yes.
The 10.2 of course says that if you have a driving license, it will entitle you to drive a motor vehicle of one or more of the following classes. Isn't it? So that will mean that you can, if your driving license would entitle you to drive a light motor vehicle, and a transport vehicle,
or a road roller, it would entitle. So our argument was that since here transport vehicle is separately mentioned, road roller is mentioned, a light motor vehicle does not necessarily authorize you to drive a transport vehicle, the unladen weight of which may be less than 7,500 kilograms, which is the definition. But your lordships in Mukund Devangan were pleased to hold that since it is mentioned there, that transport vehicle and an amendment specifically was brought in 1994, and a separate class of transport vehicle was created which subsumed the 4 other classes in it, and light motor vehicle. So if you're driving a light motor vehicle of up to 7,500 kilograms, you don't require a separate endorsement of any kind to drive a transport vehicle. So all the provisions that I have read up till 10, which deal with a separate license regime for a transport vehicle, are inapplicable if your lordship's decision or are pleased to uphold Mukund Devangan, then all these will be inapplicable to a person driving a transport vehicle of up to 7,500 kilograms. That would be the sequitur of if that judgment is upheld. So then we would be carving out a distinction, my lords, in the legislative scheme of transport vehicles which are light motor vehicles up to 7,500 kilograms, not requiring any of those other tests to be fulfilled, and transport vehicles of above 7,500 kilograms, which require these to be fulfilled by a person who is desirous of driving a transport vehicle. Though the legislature makes no such difference, but on that. So the two sections which your lordships were pleased to use in the decision were 247 for the definition of motor vehicle and 10.2 as far as the form and content of driving license was concerned. It doesn't end there. It goes a little further. And 14 becomes of some relevance, my lords, if your lordships are pleased to turn to 14.
says that
Just
11 is
11
important.
actually,
Yes,
yeah,
11.
Clarifies the context. 11 is missed out. in the
Additions to
criminal
driving
segment.
license, yes.
Very correct.
Any person holding a driving license to drive any class or description of motor vehicle who is not for the time being disqualified from holding or obtaining a driving license to drive any other class or description of motor vehicle may apply to the licensing authority in the state in which he resides or carries on his business in such form and accompanied by such documents and with such fee as may be prescribed by the central government for the addition of such other class or description of motor vehicles to the license. So you apply, if I hold an LMV, I want to drive a road roller, I will apply for that purpose. Subject to such rules as may be prescribed by the central government, the provisions of section 9 shall apply to an application under this section as if the said application were for the grant of a license under that section to drive the class or description of motor vehicles which the applicant desires to be added to his license, provided that the licensing authority may, before issuing the license, verify the identity of the applicant in such a manner. Now, please see 14, which is the currency of license to drive motor vehicle. Is currency. A learner's license issued under this act shall, subject to the other provisions of this act, be effective for a period of 6 months from the date of the issue of the license. 2. A driving license issued or renewed under this act shall, now please see this, my lords. A. In the case of a license to drive a transport vehicle, be effective for a period of 5 years, provided that in the case of license to drive a transport vehicle carrying goods of dangerous or hazardous nature, be effective for a period of 3 years, and renewal thereof shall be subject to such conditions as the central government may prescribe. So even within the transport vehicle, my lords, it is effective, the license is valid for 5 years, and if it is for hazardous nature, goods or dangerous, then it is 3 years, and the renewal shall be subject to the conditions of the central government. In the case of any other license, subject to such conditions as the central government may prescribe, if the person obtaining the license either originally or on renewal thereof, now it goes by age, my lords. 1. Has not attained the age of 30 years on the date of issue or renewal thereof, be effective until the date on which such person attains the age of 40 years, which means, my lords, if I have applied at age 20, I can have a license validity for 20 years till the age I am 40 years. Has attained the age of 30 years, but has not attained the age of 50 on the date of issue, renewal thereof, be effective for a period of 10 years from the date of issue of such renewal. Has attained the age of 50 years, but has not attained the age of 55 years on the date of issue of renewal thereof, be effective until the date on which such person attains the age of 60 years, and has attained the age of 55 years on the date of issue, or as the case may be, the renewal thereof be effective for a period of 5 years from the date of such issue or renewal. So for any other category, my lords, I have to attain a 55 years, wherein I would then get a license for 5 years and subsequently then for 5 years. For other, I can get 20, 10, that is how it proceeds. But if it is a transport vehicle, you will get it only for a period of 5 years.
Just with Nitin Devangan.
Then comes section 15, which is renewal of driving licenses. And it says, Manoj, it's at the bottom of page 324. Any licensing authority may, on application made to it, renew a driving, sorry. Any licensing authority may, on application made to it, renew a driving license issued under the provisions of the Act with effect from the date of its expiry, provided that in any case where the application is for renewal of a license is made either 1 year prior to the date of its expiry or within 1 year after the date of its expiry, the driving license shall be renewed with effect from the date of its renewal. The second proviso, sorry. Provided further that where the application is for the renewal of a license to drive a transport vehicle, or where in an other case the applicant has attained the age of 40 years, the same shall be accompanied by a medical certificate in the same form and in the same manner as is referred to in subsection 3 of section 8, and the provisions of subsection 4 of section 8 shall, so far as may be, apply in relation to every such case as they apply in relation to it.
The requirements are also different. You require medical certificate specifically for a transport vehicle.
Yes.
Including for a renewal.
Including for renewal for all, every time for a transport vehicle, in general category, in LMV, only if you have attained the age of 40 years.
Where do you get that? Where you have attained the age of 40 years? For
yes, the proviso, my lords. Your lordships has the proviso.
With the second proviso, yes.
The second proviso, provided further that the
has attained the age of 40 years.
Yes.
Sorry, I missed that.
In other case, the applicant.
In any other case, that's right. Yeah.
Then comes the power to make rules, my lords, which is at page 332.
No, fax method is probably नहीं है क्योंकि we have already.
This doesn't specifically relate to the issuance, my lords, but it relates to the state government framing rules where transport vehicles are in different page 332. That a state government may make rules for the purpose of carrying into effect the provisions of this chapter other than the matters specified in section 27. And then D, the badges and uniform to be worn by drivers of transport vehicles and the fee to be paid in respect of badges. The duties, functions of H, my lords, then the duties, functions and conduct of such persons to whom license to drive transport vehicles are issued. Then the last ones is subject to Mr. Bhushan and Mr. Kaul and the learned ASG. If there are some other sections I may have missed, my lords, is 66, which is chapter 5 at page 351.
41 also.
Says control of transport vehicles, my lords. 66, necessity for permits. No owner of a motor vehicle shall use, sorry.
Yes.
Reading 66, Mr. Dana.
66, my lords, at page 351. No owner of a motor vehicle shall use or permit the use of the vehicle as a transport vehicle in any public place, whether or not such vehicle is actually carrying any passengers or goods, save in accordance with the conditions of permit granted or countersigned by regional or state transport authority, or as prescribed, or any prescribed authority authorizing him the use of the vehicle in that place in the manner in which the vehicle is being used. Now, this of course applies to the owner, doesn't apply to the driver, can be a non-owner as well. But the endeavor here, my lords, is that according to us, a transport vehicle falls in an entirely different category than a light motor vehicle, even though it finds within the meaning and the definition. Now, these are, and there are some rules, my lords, that are there, which dealt with that. I may just briefly indicate, my lords, to your lordships, if your lordships would like to go through. It's Rule 5 deals with that medical.
Mr. Call, any other provision that may have been missed? So do you want us to read so that at this point we can complete the reading of the Act? Yes. That these are the Act. Fair. Since Mr. Dave said
Yes,
subject to.
because this.
Which one? We just look at 210, Mr.
Oh, definition.
Yeah, definition we saw from the written.
There are quite a few in definitions which we have to see.
Mr. Dave, should we just look at of course, we saw the definition in your flow chart.
Yes.
Let's have a look at it as it reads, so that.
So your lordships may come to page 308, where I've set out. Sorry, it's not bookmarked.
Driving license, right?
Yes, my lords. Motor vehicle starts with 315, my lords. The definition.
Driving license is 210.
Yes, my lords.
Just to make it complete, let's see the definitions all at one.
Yes, my lords. Driving license means the license issued by a competent authority under Chapter 2, authorizing the person specified therein to drive otherwise than a learner a motor vehicle or a motor vehicle of any specified class or description. Because a learner license is known as a learner's license. So the driving license is a license issued by competent authority, authorizing the person specified therein to drive a motor vehicle or a motor vehicle of any specified description.
Class or description?
Class or description, I'm obliged, my lords. Class or
What is a class and what is a description? What's the difference?
my lords, class may be like the class that is there, which is specified in
10, there is a, in 10 talks of a
yes.
class.
Description will come, my lords, where if it is a motor vehicle or it is a transport vehicle, there are various other descriptive classes of vehicles that are provided for, which I'll take to your lordships to. There are vehicles especially for educational institute. There is a vehicle which is for private use, which is for a public carriage, or it is for goods vehicle. So various usage would it describes them as for the purpose they are the vehicle, because the definition of a motor vehicle is also provided under this Act.
Then we had section 221, which was a light motor vehicle.
Yes. Now, light motor vehicle means a transport vehicle or omnibus, the gross vehicle weight of either of which, or a motor car or tractor or road roller, the unladen weight of which does not exceed 7,500 kilograms. Now, according to my reading, my lord, subject to any correction, there is no heavy motor vehicle and there is no medium motor vehicle. Then it goes by, as your lordships would see, below this at 223, it becomes a medium goods vehicle or a medium passenger motor vehicle. This light motor vehicle, my lords, is a description or a definition which exists only for this particular, in this manner amongst the definitions.
This definition itself doesn't indicate that the moment you have a license for a light motor vehicle, that you can, as a matter of right, you would be entitled to drive a transport vehicle or an, yes.
It does not.
This merely says that a transport vehicle or omnibus vehicle whose gross weight is less than 7,500 and a motor car or a tractor or road roller, the unladen of which, weight of which is less than 7,500 is a light motor vehicle.
Correct.
Not weight. Would be less than
right.
Transport vehicle, because usage and weight are different. Weightage is not the basis. Usage is the basis, and the judgment falls into that error, relying on section 2, subclause 21, read with section 10, and commits this error.
Right. The Act draws a distinction between the utility of a vehicle on the one hand and the vehicle in itself on the other hand.
Grateful.
So that distinction, I think, is effaced in the judgment.
Yes.
Because there are different types of usages of the vehicle, and the statute speaks about such usages in different terms.
And that's why, my lords, the license regime entirely is utility and usage based. It has nothing to do with the weight at all.
Why I was pointing out, Lord, since your lordships are on description, if your lordship just scroll up one page, your lordship will find heavy goods vehicle.
Yes.
Where it would be heavy goods vehicle means any goods carriage, the gross vehicle weight of which, or a tractor or road roller, the unladen weight of which exceeds 12,000 kilos.
Even the next one, 17.
17, I'm obliged.
17 also.
17. Heavy passenger motor vehicle means any heavy passenger motor vehicle, it specifies, means any public service vehicle or private service vehicle or educational institution bus or omnibus, the gross vehicle weight of which, or the motor car, the unladen weight of which exceeds 12,000 kilograms. Now, since we are at it, my lords, and therefore we have the light motor, we have the heavy. Now, please see medium also, which is 23 and 24. At page 317 itself, my lords. Medium goods vehicle means any goods carriage other than a light motor vehicle or a heavy goods vehicle. 24, medium passenger motor vehicle means any public service vehicle, private service vehicle, educational institution bus, other than a motorcycle, light motor vehicle, or heavy passenger motor vehicle. So you have a medium goods vehicle, which is between the two. You have a light, which is 7,500, heavy, which is above 7,000, over 12,000 kilograms, and then you have medium. I wanted to read the definition, my lords, of motor vehicle. Since we are reading the Motor Vehicles Act, my lords, what is a motor vehicle at 28? Scientifically defined. Motor vehicle or vehicle means any mechanically propelled vehicle adapted for use upon roads, whether the power of propulsion is transmitted thereto from an external or internal source, and includes a chassis to which a body has not been attached, or a trailer, but does not include a vehicle running upon fixed rails, or a vehicle of a special type adapted for use only in a factory or in any other enclosed premises, or a vehicle having less than 4 wheels fitted with engine capacity of not exceeding 25 cubic centimeters.
26 is also important.
26 meters. Motor car, yes. That's motor car means any motor vehicle other than a transport vehicle. I'm obliged. Omnibus, road roller, tractor, motorcycle. As far as a motor car is concerned,
distinction between a motor car.
As far as a motor car is concerned, is that even omnibus is there, and then, my lords, kindly come to no transport vehicle. That's first place 247. While your lordships are at page 317, just in correlation. 31 defines permit, which means a permit issued by state regional transport.
Permit we have seen.
Permit, yes.
Section
Now, please see one, Manoj, kindly see the effect. If I can just pause here for a moment, Manoj, away from the definition. The definition your lordship saw of light motor vehicle means it includes a transport vehicle or a motor car or a tractor or a road roller. It includes all those. Transport vehicle by itself is defined, which your lordships will find at 247 minutes. Now, please see the definition of 247. The transport vehicle means a public service vehicle, a goods carriage vehicle, a goods carriage, an educational institution bus, or a private service vehicle. Now, each of these, my lords, have also been defined under the Act. Each of these. So, just to take your lordships to a private service vehicle or a public service vehicle at 33 and 35, 233 and 235, my lords, is the definition. And kindly see how broad it is, the definition. So, if a person is authorized to drive an LMB, doesn't require any other permit, then he can drive, according to the judgment, any of these vehicles, my lords, including a road roller of less than 7,500 category in unladen weight. So please see 33, which is private service vehicle, means a motor vehicle constructed or adapted to carry more than 6 persons, excluding the driver, and ordinarily used by or on behalf of the owner of such vehicle for the purpose of carrying persons for or in connection with his trade or business, otherwise than for hire or reward, but does not include a motor vehicle used for public purpose. And a public service vehicle, your lordships will have a 235, means any motor vehicle used or adapted to be used for the carriage of passenger for hire or reward, and includes a maxi cab or motor cab, contract carriage, and stage carriage. So if the effect is to be taken to its logical end, a person by merely holding a LMV license is allowed to ferry passengers, and it has a certain serious consequences as far as driving is concerned, because he doesn't have to have a medical certificate, he doesn't have to hold a license for 1 year of an LMV, but he will just come on the road, drive one of these vehicles, though it is less than 7,000, and ferry passengers either privately or in a public manner also.
And probably the conditions for obtaining a license for a light motor vehicle must be different from a condition which you have to fulfill for a transport vehicle.
They're much lighter, if I can use that expression.
That the rules will tell us what the differences are.
So those are not
training, other things.
For hazardous, even more stringent, because it's not just ferrying passengers, it's also carrying hazardous material.
Chemicals,
Even the
etc.
tenure,
Oxygen.
even the tenure of the license is also limited.
That's right.
Renewal is also limited.
You can get it only at 20 for transport vehicle. Your lordship saw in the licensing regime, transport vehicle is for 20, provided you hold an LMB for 1 year before. So those conditions will all go if it has to be given the effect pursuant to your lordship's judgment.
And the insurance companies are claiming that the impact of Mukund Devangan is that you cannot plead an exclusion to your liability on the ground that the driver was not licensed. You have to pay.
We have to pay.
To which they said they would argue pay and recover, assuming that you are not liable, you pay and you recover
from the driver. As far as then it comes on the negligence aspect of it. But for our policy to be excluded, he has to have a valid driver's license. So the whole.
If he doesn't have a driving license, a valid driving license, then you are excluded.
Then we are excluded from it. What is that driving license, Manoj? Now, whether it requires separately for a transport or even an endorsement, yes, permitted to carry. Even all other licenses also are generally LMV plus motorcycle with gear, motorcycle without gear. If your lordships were, I took out my driving license and so on. LMV plus.
It all dependent on how the court construed sections 10.
10, yes. 10 is the heart.
10, I think it completely mistook subsection 2, which says that a learner's license, as the case may be,
yes,
driving license shall also be expressed as entitling the holder. What is that expressing? That expression perhaps is related to first part or even the title, the form and contents of the license.
Yes, Manoj.
It is not intended to equate it.
Such information
it was not intending to equate a vehicle.
And it also says
content with all other transport vehicles. It was not intending to equate it because it was intending to convey that the form as well as the contents of a license must be in a form, in a manner which has been there with respect to other vehicles. That was misconstrued to say that the light motor vehicle is actually equated to transport vehicle. So therefore, there is no distinction, ignoring the entirety of the scheme of the Motor Vehicles Act, which draws out a very clear distinction between a transport vehicle on the one hand and a vehicle which is meant for a personal use. That's a mistake.
As far as the licensing regime is concerned.
Yes.
In regard to that, for the licensing.
So all other provisions virtually have become redundant.
And I should be fairly state, my lord, the reason why your lordships held is because of this 94 amendment. Once those
is something else. Yeah, it's completely. 10 is only.
Yes. So your lordships read this, that since 4 categories have now been removed and all subsumed in transport vehicle, yet light motor vehicle remains. So if you are a light vehicle, a motor vehicle holder of a license of a light motor vehicle, and transport vehicle is mentioned there, therefore we will, and there are some forms which your lordships construe. I will come to those forms. The definition section, unless my learned friend wants some other section.
Also 10(2) may be an enabling provision. See, it says shall also be expressed as entitling the holder to drive a motor vehicle. It doesn't say of all the following classes. It says of any one or more following classes.
Lordship pleases me.
So every license may not include all of these, right? A to J.
But to interpret what is light motor vehicle, your lordship, the decision went back to the
meaning. Rules the license. Categories are provided. That's what you're saying.
The only reason is the definition of light motor vehicle was
restrictions on the ground.
It went back to the definition transport vehicle and therefore the authorization to drive. That is, I'm simplifying it, my lords. Of course, I'll place the judgment. Your lordships have to consider that judgment.
Construed this before Mukund Devangan.
The High Court followed, in our case, my lord, High Court followed Mukund Devangan.
And generally, what was the view of the different high courts actually?
No, my lord, once the 3-judge bench decision came.
No, before the 3-judge.
Your lordship, there were 8 judgments, my lords, which had different points of distinction.
Was there uniformity in the high courts before Mukund Devangan, or there was differences?
There wasn't.
There were several judgments which said that if you have an LMB license and you are driving a transport vehicle of less than 7,500 kilos, you are permitted. Several said that no, you are not permitted. You must have a specific transport vehicle license.
Right.
So even here there was no unanimity.
In fact, man, was the ONGC judgment, the Oriental Insurance judgment, categorically said in 2009 that light motor vehicle and transport vehicle are distinct categories. Referred to it as is obvious from the statute reading, but the judgments were there on this even in 2009.
But in my index, my lords, your lordships will find part D, which is page 9 to 10. It's difficult for your lordship to open, my lords, I know, because it's not bookmarked. Sorry, my lords.
Yeah, that's right. Your index.
Yes, my index wouldn't be bookmarked, my lords.
Page
I will
7.
bookmark it, my lords. Tomorrow it will be more easier. I have given the conflicting judicial pronouncement on a chart.
The revenue must also apply to 7,500.
So I have given, my lords, holder of LMB license LMB license must also obtain a separate license endorsement. 3 judgments there, my lords. And 4, 5, 6, 7, 8, my lord.
Now, Mr. Dave, we are making I mean, you're seeking to make a distinction between a licensing regime for light motor vehicles with a licensing regime for transport vehicles. Now, tell us, what is the licensing regime for tractors, road rollers, and motor cars?
So the motor cars are in the light motor because it's defined in LMV. A motor car finds a mention in an LMV itself, my lords.
Now, is there a separate regime for tractors or road rollers?
Tractor is not mentioned separately, but road roller is mentioned, my lords, in the definition.
But the licensing provision, is there a separate licensing provision for road rollers?
Yes, ma'am. And 10.2 read with Form 4. The Form 4 that you apply under also has a separate road roller category.
Not for a tractor.
No, I said road roller. Transport vehicle, light motor vehicle, and road roller.
Not for a tractor.
Yes. E-rickshaw also, e-carts also.
Now, not for an omnibus also.
Not for an omnibus.
Not for an omnibus. That's a lacuna in the law.
The moment you have a light motor vehicle license, you can drive an omnibus, tractor.
Road roller is provided.
Road roller is provided for.
And rickshaw, I think that is exception. Or of any other category like a trailer, etc. You have the J category, which is of a specified description because they're not. But it could be, my lords, the 7th specified description would be like an earth excavator, when the road is being constructed, etc.
But if you have to conceptualize Section 10, Mr. Dave, how would you conceptualize it? What is the purpose of Section 10?
I would say that Section 10, my lords, is a section which only provides for enabling a person to drive a particular class of vehicles. It does not necessarily mean that he is entitled, if LNB is mentioned, he can drive all those vehicles which are mentioned as far as the definition is concerned. One necessarily has to start from Section 3 as far as the licensing regime is concerned. And the licensing regime, my lords, cleaves. It cleaves, my lords, into one, transport vehicles, and of other category, which is primarily motor car.
We'd also like to see the rules now, so that's how the act is implemented.
I've got the rules. I've got the rules, my lords. Rules are page 436, my lords. Open it in this.
Made under 10, under 10.1, it says as prescribed.
Yes,
Rule 16. Now, what do the rules provide? We'll have to go to the rules actually.
They start, my lords, at page.
You've given us the rules as well?
Yes.
Where are they? Page?
They start at page 436, my lords.
But you don't have the contents of it.
Just the contents and.
Henna. 99. Just.
Before your lordship goes to the question that fell from the Honorable Chief Justice. Now, in any case, under the Act itself, under 10, transport vehicle is a separate category altogether. Does it mean that we have to go back for LNB to see that transport vehicle which falls under LNB will be automatically authorize a person to drive a transport vehicle? If transport vehicle is mentioned as a separate category altogether. The further dissection that comes, my lords, is that for LNB, if you hold a license for a transport vehicle, you will be authorized to drive it, though transport vehicle is a separate class which is mentioned in Section 10 of the Act itself. So it is no longer it's not open to us to interpret that for LMB, you can drive a transport vehicle, but for all other categories, the transport vehicle will be above 7,500 kilograms, which distinction is not there in the section itself in section 10. That is my submission for your lordship's consideration. If there is a category of transport vehicle, it will apply to all transport vehicles.
Their contention is that, the legislature, by definition, equated transport vehicles with a unladen, with a weight of less than 7,500 in the same class as light motor vehicles.
Because the definition of transport vehicle doesn't have a weight issue.
Right.
The definition of transport vehicle only provides for the categories of vehicles which are included. It's like a more of a.
So every transport vehicle is not a light motor vehicle. No. But if the weight is less than 7,000, it's by definition a light motor vehicle.
It becomes a light motor vehicle. So if in 10 there is no qualification for the definition of transport vehicle of less than 5,000, then I could understand that it can go back to LMV and the definition of LMV. But after D, there is an E, which says transport vehicle. So now transport vehicle is by a class itself. All those vehicles which are covered by that definition of a transport vehicle will automatically be covered, and you require a separate endorsement or a license to drive a transport vehicle. There is no occasion to go back to the definition.
You're right, because 10 makes a distinction. It elaborates both, itemizes transport vehicles and light motor vehicles separately.
Yes. So to go to
but it becomes transport vehicle if it is put to use as a
the definition of
public service vehicle, goods vehicle, and so on.
Right.
And they are
distinctly.
In fact, because it is clarified by the legislature now that if it is a transport vehicle which is unqualified, so regardless of the category that it falls under, regardless of the category that it falls under, it would be covered. You would require a special endorsement to come. Utility. It is a transport vehicle. Otherwise it would have provided, the legislature would have provided the transport vehicle under E, which is an amendment that is bringing to the act of 7,000, above 7,500. Because it would have intended that below 7,500 transport vehicle is covered under LMV.
Now, apart from this, now what is the next line of?
And the judgment. That's why I said yesterday it's not a very.
It's a short point.
It's a short point.
Actually, you have covered almost all the ground. Then we will hear the perspective from Mr. Bush and Mr. Coyle. The statutory provisions we have now seen. Perhaps like to look at the rules, because that implements the statutory regime by having separate. Are there separate regimes for obtaining an LMV license, light motor vehicle license, a transport license?
It is in addition, so it defines things like how a medical certificate is to be issued under Rule 5, who is to apply for a medical certificate, learner's license and a driving license. How is it to be issued?
Does it have a separate register for transport vehicles?
Forms. That's what your lot.
Does it have a separate?
Forms are separate.
Forms are different.
Yes. I wanted to point out that below.
Forms are separate. Your lot. I will bookmark it.
Can you just
I'll bookmark it.
The act speaks about the first chapter, different types of licenses. Specifically provides so far as the rules are concerned.
Yes, Manoj.
Now it speaks about the usage of forms.
Yes.
Commencing from 1 to as many. So this forms need to be taken.
Yes.
For transport vehicles, non-transport vehicles, and other things.
Yes.
So just make a small tabulated form.
I'll do that, and I also bookmark below. It will be inconvenient.
Now you will understand.
Just do a little analysis on a piece of paper and give us the.
In the rules, Milord, I was just checking Mr. Dave's compilation. I could not find, but in the table in the motor vehicles rules, Milord, there is a difference has been given of transport vehicles and non-transport in a tabular form. And Milord, it says everything, even the heavy motor vehicles. So Milord, all the transport vehicles are not LMVs, Milord. That's Milord, our case, Milord. This separate, Milord, the table which has been given in the rules. I could not.
The way there's a more fundamental, more profound issue which we'll have to look at overnight.
There is a clear table.
Is the boxing analogy of light, medium, and heavy taken from the Motor Vehicles Act or what?
I think motor vehicle act took it from the boxing. So that's a sport which goes back ancient time. I don't, there's no welterweight or light flyweight, thankfully, or otherwise complicated issue. I'll
We'll
be
come tomorrow. We'll come tomorrow. And, how long would it take?
I just have, apart from that distinction which is followed from the lordship.
After that, now who will be arguing? Mr. Bhushan, then Mr. Paul, and then solicitor will follow after that. What's the plan of action? No problem. And solicitor is leading whom?
Miss Pathak.
Miss, the way you order. And then the all
The victims are.
fair enough.
Because the matter is already listed, they refuse to.
We'll hear you. Absolutely. Please assist us tomorrow. Certainly, Mishra, please assist us.